Good afternoon. The Appellate Division First Department is now in session. Welcome to our virtual oral argument session for Thursday, January 7th, 2021. I will now call the calendar. First case, People versus James Haney. Appellant?
Yes, good afternoon, Your Honor. Whitney Elliott of the Legal Aid Society for the appellant, Mr. James Haney.
Okay, you have 6 minutes for argument and 1 minute for rebuttal. And the respondent?
Yes, Your Honor. Michael Tarbutton for the People.
Thank you, and you have 6 minutes to argue.
Thank you, Your Honor.
U.S. Bank versus Nunez, the appellant.
Good afternoon, Your Honor. James Gentrosami for the appellant.
Okay, you have 5 minutes and 1 minute in rebuttal. Respondent?
Good afternoon. This is Ryan Sirianni from Greenberg Traurig for the respondent.
Okay, and you have 5 minutes for your argument. M. Athena is submitted. Cordova versus 653 11th Avenue is submitted. Estrella versus Montefiore Medical Center, appellant.
Appellant Arnold D. Joseph for the appellant, Your Honor.
Okay, good afternoon. You have 5 minutes for argument and 2 minutes in rebuttal. Respondent?
Good afternoon, Your Honor. Esther Wadowski for respondent, Montefiore Medical Center.
Okay, and you have 5 minutes for your argument.
Thank you.
Brian, welcome. People versus Brian Quattrochi, appellant.
Good afternoon, Your Honor. Barbara Zolat, Center for Appellate Litigation for appellant Brian Quattrochi.
Okay, you have 6 minutes and 2 minutes in rebuttal. The People, respondent.
Good afternoon, Your Honor. Victoria Meath for the People.
Okay, and you have 6 minutes to argue.
Thank you.
Nation Star Mortgage versus Generation Mortgage, the appellant.
John Bridie on behalf of the appellant Nation Star Mortgage. Good afternoon, Your Honor.
Good afternoon. You have 7 minutes and 2 in rebuttal.
Thank you.
Respondent Generation.
Good afternoon, Your Honor. James Wicks from Farrell Fritz for respondent Generation. I think we requested 7.
Yes, well, we gave you 7 and respondent Guggenheim.
Good afternoon, Your Honor. Martin Gagan from Winston and Strawn on behalf of the defendant, Guggenheim Partners, LLC.
Okay, and you have 2 minutes. Nwanji versus City of New York is submitted. Narvaez versus City of New York. The appellant Everest Scaffolding.
Valerie Prezimenter from Fuchs Rosenzweig for the appellant.
Okay, you have 6 minutes for argument and 2 in rebuttal. Respondent City of New York.
Yes, Your Honor. Daniel Monster Brown for the City of New York. I believe we requested 4 minutes.
We gave you 4 minutes. And respondent Narvaez, plaintiff.
Good afternoon. Aaron Feim for plaintiff's respondents.
Okay, and you have 4 minutes. The next case is People versus Alberto Pena. That is submitted. Hadid versus City of New York, the appellant.
Good afternoon, Your Honor. Nathaniel Smith for the appellant, Bobby Hadid.
Okay, you have 5 minutes and 2 in rebuttal. And respondent City.
Good afternoon, Your Honor. Deborah Brenner for the respondent City of New York.
Okay, and you have 5 minutes.
Thank you.
Backcourt versus City of New York, the appellant. Mr. Shute, I see you, but you're not, you're muted. Okay, well, I see you, so I assume you'll figure out how to unmute by then. You have 6 minutes and 2 in rebuttal. Is the respondent available?
Good afternoon, Jameson Davies for the City of New York.
Okay, and you have 5 minutes. Augusto versus 1 Sidori Lane, appellant.
Good afternoon, Your Honor. Kristen Llaneros for the appellant.
Okay, you have 5 minutes and 2 in rebuttal. The respondent.
Good afternoon, Your Honor. Jeff Schiethelt from Pena and Khan for the respondent.
Okay,
and I believe I've been given 5 minutes.
Yes, you have. That's correct. Next case, People versus Anthony Thomas, the appellant.
Yes, Your Honor. Shane Baumgartner from Gibson Dunn on behalf of Mr. Thomas.
Okay, you have 6 minutes and 2 in rebuttal. And respondent people?
Good afternoon, Your Honor. John Hughes for the people.
Okay, and you have 6 minutes. Scottsdale Insurance versus RLI Insurance, the appellant.
Good afternoon, Your Honor. Timothy Delahunt for appellant RLI Insurance.
Okay, you have 5 minutes and 2 in rebuttal. Let's see, Scottsdale, I guess you're the respondent.
Hi, good afternoon. Ann Odelson for the respondent, Scottsdale. I believe we have 5 minutes.
Yes, and also respondent State of Pennsylvania Insurance Company.
Yes, Elizabeth Allstrand for the insurance company of the state of Pennsylvania.
Okay, we gave you 5 minutes also.
Thank you.
The next case is Chai Chen versus Kui Lee. That's submitted. Paulino versus MTA Bus. Appellant.
Yes, for the appellant, Your Honor. Good afternoon, William Morrissey for the appellant. I requested.
We gave you five minutes
5,
and 2
yes.
rebuttal. Respondent.
Good afternoon, Your Honor. For the respondent, Oliver Tobias.
Okay, you have 5 minutes. And Sands Brothers versus Park Avenue Bank. The only person that asked for argument was the appellant, Mr. McCarthy. For G Group. Okay, we gave you 5 minutes. No one else is appearing. And Last Week versus LSG Sky Chefs, the appellant.
Good afternoon, Your Honor. Deborah L. Sasser for the appellants. And Your Honor, in advance of the argument, I just want to apologize. I tend to get some sirens on my street. So if that happens, hopefully not, I apologize to the court.
Oh, well, hopefully those 5 minutes, it'll be quiet. We've given you 5 minutes. And the respondent on that case?
Good afternoon, Your Honor. Evelyn Gross from the Law Office of Gray and Gray for the respondent.
Okay, we've given you 5 minutes. Okay, so I just want to remind you first that everybody should keep their mics muted so we don't get any feedbacks until, of course, your case is called. And also, I want to remind you that you would never want to talk over the judges, but be particularly careful now because in this format, it's a little bit more difficult, as I'm sure we've all learned over these many months. So the first case we have for oral argument is People versus Haney. Whitney Elliott, you have 6 minutes.
Yes, thank you, Your Honor.
Okay.
May it please the court. I wanted to start by emphasizing what I think are the 3 main points on the merits of our forfeiture argument. First, the forfeiture that issued here did not properly issue under CPL 220.50 because it did not result from an agreement between the defendant and the prosecution. Instead, it resulted from an agreement between the defendant and the court. For that reason, the 220.50 sub 6 did not authorize it.
Counselor, if this is Judge Mazzarelli, if we find that the waiver is valid, then your argument regarding the forfeiture is not relevant anymore, is it?
Yes, it would still be relevant, Your Honor, and I think that's so for at least 3 reasons. Number one, obviously we disagree that the waiver is valid, but our first reason would be that the terms of the waiver, the oral colloquy and the written waiver, did not expressly cover the forfeiture that happened in this case. Second, is that we think that the forfeiture, our forfeiture challenge relates to the substantive legality of the forfeiture. That is, that the forfeiture was not authorized by the statute that it purported to operate under. So just as claims, for example, relating to the legality of a sentence survive even a valid appeal waiver, so too do claims relating to the legality of a forfeiture. So yeah, and for those basic reasons, even if the court did uphold the waiver, we think that our forfeiture claim would survive. But with respect to the waiver, I would say I think the cleanest way for the court to address that is by applying the Second Department's decision in Sutton, which says that a waiver that results from a plea agreement between the defendant and the court, rather than the defendant and the prosecution, is invalid absent
Well, that
reasons.
kind of puzzles me, your statement there, because your client did not plead guilty to the entire indictment. Am I correct?
That's correct, Your Honor.
So therefore, the people had to consent to the plea.
So, in one sense, that's true, Your Honor, but I think that
What do you mean,
statement
one
right there,
sense?
Your Honor,
What do you mean in one sense? The people have to, if the defendant does not plead guilty to the entire indictment, and the court is not going to impose the sentence that the people want imposed, then they have to consent to it. They've consented to it. They didn't get the sentence they were looking for.
So, Your Honor, that point, I think, with respect, conflates two separate and distinct points, and this is, I think, critical to Sutton. One is whether the prosecution would have a legal right to stand in the way of the plea as the court has proposed it.
Why
and that's a distinct issue. I'm sorry, Your Honor, go ahead.
Why wouldn't they? If the court is going to take a plea that is not based on what the prosecution is offering, then the court has to take the plea to the entire indictment.
So, no, it could happen as in Sutton, and as in this case, it often happens that a court will often offer a plea to the top count as the court's own proposed plea, and that the prosecution, for whatever reason, does not object to. So I just want to emphasize, and this point is critical, Your Honor, with respect. The question of whether it is a court-initiated plea under Sutton, I think, is a factual question, and that is, on the record, was this an agreement between the court and the defendant? That is distinct. That factual question is distinct from the legal question of whether could the prosecution have objected to this plea or insisted upon a plea to the indictment. Even if the answer to that question is yes, that doesn't mean that as a factual matter, it was a party to the agreement. And in fact, this kind of circumstance, a plea to the top count in the indictment, that was what was happening in Sutton. It was happening in the other two Second Department cases.
Well, we're not found by the Second Department, as you well know.
I agree, but again, I just don't. The court, I think, with respect, the court should not conflate the two questions of whether, as a matter of fact,
I try never to conflate anything. I mean, I always try to keep every argument separate and distinct.
But I just think this is critical to whether the prosecution could have objected, and if they did, all that would have been required is to say, okay, plead to the rest of the indictment, and we'll go forward with the agreement from there.
But
and I think that's why.
Counsel, isn't the prosecution's consent presumed by, as Judge Mazzarelli said, the fact that the defendant did not plead to the full indictment, and isn't that what CPL 22010 says?
Well, that they did not object, but I think that's a different question of whether they were a party to the agreement. If they had objected, then the agreement, as in fact the defense asked for here, he could have just pleaded to the entire indictment, and the plea would have gone forward with the same terms that the court had proposed. So, and again,
okay.
Again,
why don't we hear from the people, and then anything else you want to add, you can do that. You have a minute for a rebuttal. May I hear from the people, please?
Yes, Your Honor. Michael Tarbutton for the people. As to the Sutton claim, Your Honor, and to the appeal waiver, this case doesn't fall within Sutton, even if the court wanted to apply it. It's true here that everything on the record here suggests that the people did consent to the claim. They didn't object like they did in Sutton. They also permitted the defendant to plead to 3 counts rather than all 14 counts of the indictment. And the court, when it was explaining the requirement that the defendant waive his right to appeal, told the defendant that was a requirement of the agreement he had between, he said, you, me, and the government, the people. So the court was telling the defendant that this was an agreement to which the people consented. To the extent that there's any ambiguity in the record, that cuts against the defendant. He has a Kenshin problem. People versus Kenshin, the record has to be adequate to support his claim, and under People versus McLean, it has to support that claim conclusively for him to bring the claim on direct appeal. So if there's any ambiguity in the record's inadequate. But the extant record actually does show that the people consented to the claim. Further, Your Honors, there are also other reasons for not applying Sutton. For one thing, if the if the people hadn't consented to the claim, it's certainly clear from this record, conclusively clear, that the appeal waiver originated from them. There's an off-the-record conference in the beginning of the plea proceeding. We know from the subsequent record, when the court makes reference to that the prosecutor at that point laid out the people's plea offer, which was a 8-year sentence, the appeal waiver, and the forfeiture of the drug money. And then when the court goes on the record, the first thing it says out is the 6-year plea offer that otherwise tracks the terms of the people's plea offer. So it certainly appears like the court crafted its alternative offer to gain the people's consent, and certainly appears again that it got the people's consent. But even if the record didn't show that absolutely, it certainly showed that the plea offer here didn't originate from the appeal waiver requirement, originated from the people. The court is making that requirement of its proposed disposition to give the defendant his lesser sentence and the people their appeal waiver. So even if you reply Sutton, there's no reason here to suspect that the court had any nefarious motive for requiring an appeal waiver. That came from the people. It was not, as Sutton said, an appeal waiver that the people weren't interested in. That's what raises the suspicion that Sutton recognized. But in any event, Your Honors, even if this had fallen under the ambit of Sutton, this court's already rejected the same argument raised in Sutton in People versus Green and People versus Napier, and it did for good reason. Sutton is an unwarranted suspicion of the trial courts. And trial courts, after all, are entrusted with a great deal of discretion, a great many rulings, pre-trial and during trial, and all sorts of contexts. It's anomalous, and it's certainly unwarranted to suddenly suspect a court of trying to bury a dubious ruling in this context, particularly since most pre-trial rulings are effectively insulated from appeal by the guilty plea itself. It's only a very narrow category of claims that would survive the guilty plea and that are not unwaivable that the Sutton rule would even apply to. So it's an anomaly. It's to be suspicious of the court in this context and no other. Further, Your Honors, the Sutton also disregards the role of defense counsel. If defense counsel, who's vigilant to protect the defendant's rights, thinks it's a good idea for the defendant to bargain away his right to an appeal in exchange for a lenient sentence, it probably is a good idea for the defendant. So that Sutton has, again, it is unwarranted suspicion of the trial court, and it disregards defense counsel's role. In addition, Your Honor, a court does have an independent interest in promoting waiver of appeal because that promotes judicial economy. The fact that it's the economy of this court rather than the trial court doesn't matter. It still promotes the conserved judicial resources. So, Your Honor, and as to the appeal waiver claim and to the counsel's claim about the forfeiture, this did satisfy the CPL because the record shows that the people consented to this. If there's any ambiguity, the defendant can establish that claim. And as the civil forfeiture, Honors, this forfeiture was authorized independently by the CPL and by the Article 13 of the CPLR. So even if it failed in the CPL, it still stands in the CPLR. So there's no reason, Your Honors, to question either the general appeal waiver or the civil forfeiture. And of course, the challenges to the forfeiture are waived by the defendant's general waiver of appeal, by the waiver provisions in the forfeiture stipulation itself, and defense challenge claiming that the forfeiture stipulation doesn't comply to the statute that's completely unpreserved. The defendant never raised that argument below. He had plenty of time to. He signed the stipulation during the plea. He could have raised it any time before sentence, and he didn't. In his brief, defendant points to the fact that he allegedly was reluctant to go forward with the forfeiture. Even if that were so, it doesn't articulate the legal claims it makes here, and it's actually not so. Defense counsel made a passing reference to defendant having already forfeited a $20,000 truck in a separate proceeding, simply in support of his pitch for a lesser sentence for the defendant. He never said he wasn't willing to forfeit the drug money in this case. He also had no defenses. The cash, after all, was seized in close proximity to the drugs themselves, so it was presumptively drug proceeds, and there was no way he was going to win if he litigated that.
Okay. All right. Thank you. I think we have your argument, and we'll read your briefs. Mr. Elliott, you have 1 minute for rebuttal if you'd like to respond to anything.
Yes, I'm going to try to make a few quick points. One other reason I had forgot to mention about why this would survive even a valid waiver is our forfeiture claim under Burgos does involve a voluntariness component, and those claims, as I think even the other side concedes, do survive even a valid appeal waiver. Second, in terms of why Sutton is right, I think Sutton, two important cases that Sutton applied. One was Seaberg, which is the only reason we're going to allow appeal waivers at all is because they will be supervised by neutral trial courts. And preventing court-initiated appeal waivers for that reason is consistent with Seaberg. It's also consistent with Towns, which says that courts may not participate as counsel would for procedural or substantive advantage. I don't think that there's any dispute that in negotiating an appeal waiver from a defendant gives the prosecution a substantive advantage. Finally, as to preservation, Burgos says a challenge to forfeiture is preserved if the defendant expressed unwillingness to proceed if forfeiture was a condition of the plea or the sentence. That's exactly what happened here, and that's why it's preserved, Your Honor. Thank you very much.
Okay, thank you both very much. Have a nice afternoon. Thank you for the arguments. Next case, U.S. Bank versus Nunez, the appellant.
Yes.
I'm not sure if I can pronounce your name, but
It's Jan Tarasami, Your Honor.
okay. You may
Common
proceed.
issue that I face. Okay. Good afternoon, Justices. May it please the court, my name is James Jan Tarasami, counsel for the appellant in this matter. The issue in dispute on this appeal is how to account for certain statutory tolls of the deadline provided by CPLR 3215. In a residential mortgage foreclosure, 3215 provides a one-year period in which the plaintiff must move for an order of reference to fix a defaulting defendant's default on pain of dismissal. I think it's going to be useful to start with the dates that are not in dispute in this case. And I want to note that there are no factual disputes over dates in this record. There are only disputes over the legal significance of those dates. There is no dispute that appellant defaulted in the underlying action on July 2nd, 2013. There is no dispute that
Justice Kennedy, and can you tell me why it would not constitute sufficient cause with respect to a reasonable excuse for the delay? Defendant filed for bankruptcy 4 times. And the plaintiff participated in the residential mortgage foreclosure settlement conference. So why doesn't that constitute a reasonable excuse for the delay in timely seeking an order of reference?
Okay, there are 2 issues there. The first is the bankruptcy, and the second is a stay purportedly invoked by the settlement conference process in Supreme Court. So let me first address bankruptcy. So we concede, of course, that it is appropriate to toll the respondent's time to move for a default for so long as a bankruptcy stay prevented plaintiff from moving forward in the foreclosure. But when you count up all of the days, okay, in the 3.5-year period in between the date of my client's default in the foreclosure and the date that we brought the 3215 motion to dismiss, that's a 3.5-year period, okay? And during that 3.5-year period.
Counsel, even if we were to agree with you that the plaintiff did not timely seek an order of reference in this case, didn't the fact that the plaintiff demonstrated it did not intend to abandon the action by their participation in the foreclosure settlement give it an opportunity, a good excuse for being a little bit late for this? Can't they avoid that even if they were late technically?
No, Judge, because the Seidner case that is discussed in the briefs for both parties, but particularly in appellant's reply brief, stands for the proposition that
that is the second department case, right?
It is a second department case, but the reasoning is cogent, and it stands for the proposition that when there is a long period of delay in bringing a motion for default, and the plaintiff is able to account for a portion of its delay through, let's say, various excuses, including participation in mandatory settlement conferences. Nonetheless, the plaintiff is required to account for all of the period of its delay, not just a portion. So there needs to be an excuse for all of that 3.5-year period. Now, we concede that there is an excuse for a portion of it, but not for 479 days worth of the delay. Okay, for 479 days as taken up, and there are competing tables, okay, of the dates in the parties' briefs. when the foreclosure was stayed and when it wasn't. Okay, and I think the key point for the court to bear in mind as it compares and reviews those competing tables is applicable bankruptcy law. Okay, the section 362C2 of the Bankruptcy Code provides that the automatic stay is canceled on the earliest to occur of the date that the petition is dismissed by the bankruptcy judge, the time that the case is administratively closed by the clerk, and or the time that a discharge is granted or denied. Now,
this is Judge Mendez. This is where I have the problem with your argument, is that whenever the plaintiff begins to move forward in prosecuting this action, your client files for bankruptcy, which stays everything, or there's a settlement conference, which stays everything. And unlike the case that you're citing, where there's a long gap, there's actually a long gap, and there's no intervening bankruptcy filings or settlement conferences. That's not what we have here. What we have here is somebody begins an action, and when the plaintiff is about to move for an order of reference, there's a bankruptcy filing. And then even as soon as that one has expired, then there's a second bankruptcy filing. And then there's a settlement conference, which also stays everything. And then there's a third bankruptcy filing. So how is the plaintiff to know? How is the plaintiff to know when to move for an order of reference?
Two very quick responses to that, Justice Mendez. First, the plaintiff in this case appeared in Florida Bankruptcy Court and successfully moved for relief from the stay in May 2016, okay? Having gone through the exercise of obtaining relief from the stay, why did they not then move forward and take a default in the New York foreclosure action? Presumably that was the reason they appeared in Florida in the first place.
Because before they did that, they needed to do a settlement. It was a mandatory settlement conference.
They did not, Judge. This case is not subject to mandatory settlement conferences because it's an investment property. And the requirement 3408 only applies to primary residences.
Okay, can I ask, you've used your time, so we'll hear from the other side and then you have a minute to respond if there are any other questions. Can I hear from Mr. Siriani?
Yes, good afternoon, Your Honors. As counsel for the appellant, I agree with him that the parties have competing tables. There's a lot of events that started and stopped the tolling of the one-year deadline to move for default. So I'm not going to get into the tables, but I would like to address CPLR 3408. I think that's where the rubber hits the road in this case. It hasn't actually been brought up yet, but I just wanted to point out that the plaintiff's argument that 3408 applies to toll the deadline, it has been preserved here on appeal. It is a question, I'm quoting a Second Department recent case called Moan, and this court's well aware, I'm sure, of when there's a question of law which appears on the face of the record and which could not have been avoided if raised at the proper juncture, it's appropriate to address it on appeal. And I think counsel for the appellant agrees that there are pretty much purely questions of law here on appeal. So the argument is preserved, number one. Number two, 3408 does apply. Appellant argues that, well, no, the statute doesn't apply because the appellant resided in Florida and she doesn't. It's the property in New York is not her primary residence. But I mean, it's undisputed that 3408 conferences were in fact held. Plaintiff filed the RJI to request the conferences. The parties were in that foreclosure settlement conference part. So once the parties are in the part, the 3408 stay of the foreclosure applies. And again, no one disputes that these conferences were not held. And then I could address Seidner, right? So Seidner is a Second Department case. It does say the court there that because the case was not subject to 3408 conferences to begin with, that the stay doesn't apply to toll the one-year deadline. However, first it's a Second Department case, but I would argue that that statement is dicta. In Seidner, the plaintiff waited about 2.5 years. I'm sorry, the case was they requested the settlement conferences well after the one-year deadline passed.
Let me ask you something. How long was it that the plaintiff failed to move for an order of reference in this particular case based on defendant's default? I mean, I think I was counting up, it was, well over a year, even with all the tolling time in the midst of that.
Oh, until when did plaintiff actually affirmatively? Okay, so first my response would be is that the relevant date that we're counting towards is when appellant filed the motion for default, or filed the motion to dismiss and say, hey, this is when I'm entitled to the relief of dismissal. She filed that in 2017. And it's my contention that after you account for the tolls, only 205 days passed since her default to when she said, I am now entitled to dismissal, which is on January 3rd, 2017. So I'm saying that 205 days passed. A large chunk of that was 187 days where really nothing happened. Ms. Nunez defaulted, 187 days passed, she files for her first bankruptcy. That's a good chunk of time. But then after that first bankruptcy was filed, she files her second bankruptcy the day after her first one was closed. Then plaintiff does in fact he's right, plaintiff receives relief from the order. 18 days after that stay, the bankruptcy stay is lifted, plaintiff files the request for judicial intervention seeking the foreclosure settlement conferences. So again, 3215C, it talks about dismissing the complaint as abandoned, right? So plaintiff thought it needed to request those settlement conferences, and it did only 18 days after that stay was lifted. So you really can't say that plaintiff was abandoning this action. No, it's doing the right thing, trying to get the borrower in court, try to hash out a potential settlement. So it was definitely proceeding with the action. And then I'd like to get to, so even if though.
You have 1 more minute, so you got.
Okay, I'll go very quick. So even if the year had lapsed, right? Even if the year lapsed, the plaintiff can still show, quote, sufficient cause as to why an action should not be dismissed. And I won't get into the standard because I have a minute. It's quoted in the brief. The first prong, reasonable excuse, as I said, plaintiff thought that it needed to do the right thing and request those mandatory foreclosure settlement conferences. It didn't know where the borrower lived, right? It didn't know if she lived in Florida or New York. So it proceeded to those mandatory conferences. And lastly, Lubonti, the Court of Appeals last year, to Justice Mendez's point, it discussed the power that a borrower has to stay a foreclosure proceeding as it relates to the statute of limitations tolling. So it's a very analogous context of tolling and statute of limitations versus tolling this 1-year deadline. And I'll just read it very quickly. The Court of Appeals says, in short, the stay brings any potential ongoing litigation to a standstill at the debtor's behest. Plaintiff's use of the automatic stay and his control over the timing of its application and revocation have the effect of halting the pending litigation and staying the commencement of the action for more than 4 years. So similarly here too, right? Ms. Nunez had complete control over when she could stop this foreclosure from proceeding. She did 4 times. I should mention, I don't think any of those, and it's in the record, none of those bankruptcies were proceeded to completion. They were all dismissed at some point. So none of them finally were found, meritorious such that her personal.
Okay, thank you. We will take a look at that. Mr. Jantrasamy, you have a minute. I just want to ask you if you could address, even if, as I said, we were to agree with you that the plaintiff had failed to move for reference within a year, move for a default within a year. And even if we were to agree with you that in this particular fact pattern, the settlement conference was not necessary. What you're asking us to do is to penalize the plaintiff for trying to settle it, trying to resolve it, and clearly not being interested in ignoring the accident, the action, but to somehow try to see if there was a way to work it out before they defaulted your client, who admittedly had not been paying for a long time. So, could you address that?
Sure. And Justice, there's no penalty to the plaintiff here by following the rules laid down in Seidner. The reason there's no penalty is because dual tracking is common. It's the normal practice in foreclosure cases, or it was for many years, that where no mandatory statutorily imposed stays are imposed by 3408, the plaintiff is allowed to and should proceed both to pursue loss mitigation discussions as well as proceed with taking a default, with seeking an order of reference, with moving the case forward so that interest and fees do not unnecessarily accrue and wastefully deplete the borrower's equity in the subject property. And now, just very quickly in rebuttal, I wanna just address 2 points. And the first one is what's preserved and what's not preserved on this record. Okay, in the proceedings below, the respondent argued only that bankruptcy stays imposed by the bankruptcy code prevented it from moving forward for the entire 3.5-year period of delay. Here on appeal, we have new arguments, right? New arguments based on supposed 3408 stays, which don't apply, but they're not preserved and they shouldn't be considered by this court. The last point that I'll make in rebuttal is that Seidner cites to Uniform Rule 20212 AC7 for the proposition that that there is no stay of for the proposition that settlement conferences in a case that don't require settlement conferences do not trigger any stay of motion practice. They don't prevent a plaintiff from moving forward to take a default.
Okay, well, thank you both very much. We'll take a look at the cases and the statutes again. Thank you very much.
Thank you.
The next case for oral argument is Estrella versus Montefiore Medical Center. Mr. DeJoseph.
Good afternoon, Your Honors. Arnold DeJoseph for the plaintiff appellant. In this medical malpractice case that was dismissed on summary judgment, the issue is whether or not the continuous treatment doctrine applies. It's the plaintiff's position that this is the poster child for continuous treatment. Let's take a common sense approach to this case. The plaintiff goes in October of 2012 and has a CAT scan that shows a lesion in her liver. Nothing is done about it. Then within the statute of limitations, she goes back to Montefiore, the same facility, and then is diagnosed and begins treatment. In fact, within 5 days, she's having surgery on her liver, all within the statute of limitations. Yet somehow it's the defendant's position that this should not be continuous treatment. What was she supposed to do at that point? Well, wait, time out. I don't care that I have been misdiagnosed. And this is a 22-year-old too. I don't care that I have liver cancer. I'm going to switch facilities now because maybe I got misdiagnosed and have a case. This is why they have the continuous treatment doctrine, is so that a plaintiff isn't put in this type of position, especially in a life and death healthcare situation. So, you know, here the court below, for whatever reason, under Edmonds, didn't give the plaintiff the benefit of the doubt. This certainly wasn't a ploy to try and renew the statute of limitations.
Isn't the problem, Mr. DeJoseph, that between October of 2012, when she first went to the emergency room, and then she was referred to another doctor, and she really never followed up with that doctor. And then when she went back on February 24th of 2015, when she was diagnosed with something else, that did not, in fact, constitute a course of treatment. It was for something else, and she didn't anticipate or intend that there was going to be any course of treatment. I mean, nothing happened for those almost 2.5 years. I know it was within the statute of limitations, but isn't that the problem that Judge Silver found, and isn't that the problem that we have here?
That is the issue you have here, but this is not this is a summary judgment motion. It's not the trial, and I want to go back to that because, in fact, in the October 4th admission, they wanted to. Well, she should be sent for a follow-up MRI. There were things that should have been done, and that's where the issue of malpractice comes in. That I didn't want to get into is whether or not she was told about the liver condition. That's the malpractice here. That's a question of fact. But then she went in for that condition, okay? It's the defendant saying to you, well, that's not the same condition. She went in for having stomach pain, abdominal pain. She found to have a cyst and to have this lesion in her liver. The cyst, they recommended it to a doctor. She went. The liver, they didn't tell her. And then she goes back for the same condition, the liver, having abdominal pains, and now she's diagnosed within the statute of limitations. She certainly undergoes a course of treatment at that point. And now she's put in a position where, wait a minute, forget it. in order to have a lawsuit, I got to stop and go sue Montefiore now, and I'm having surgery.
I mean, I get all that, but didn't she have to prove some evidence or provide some evidence of an ongoing relationship of trust and confidence with Montefiore? And that's why I said at the beginning, she never followed up with Montefiore or the doctor that they apparently referred her to shortly thereafter. So how do you have that ongoing relationship that is like the basis of the continuous treatment?
I understand, Judge, because the case law allows for this. It says, hey, listen, it's not a ploy. You went back within the statute, and within the statute, now you began the course of treatment. This idea that we have this, because what does the defendant call it? She doesn't call it continuous treatment. She calls it a renewal of treatment, in quotes. Okay, and what the renewal of treatment is, it's actually the course of treatment that began at the same facility within the statute of limitations. And, you know, that's why it's a question of fact for a jury and not to be dismissed as a matter of law. That's the argument, Judge.
Okay, thank you. You will have 2 minutes on rebuttal. We'll hear from the respondent now. Thank you. Ms. Wadowski?
Yes, Your Honor. Good afternoon. Can you hear me?
Yes.
Okay. May it please the court, Esther Wadowski for respondent, counsel for respondent, Montefiore Medical Center. Respectfully to plaintiff's counsel, it's not what defendant is calling a renewal of treatment. It's what the case law calls a renewal of treatment. And in analyzing this case, on the motion papers and also Judge Silver below, accepted plaintiff's version of the facts as true. And accepted that there was the same condition at both visits to the emergency room that were 28 months apart. But that's not the end of the inquiry. Although there was a lengthy gap, the gap is not dispositive, but there's more to the analysis, specifically whether there was a continuity and a consistent treatment or monitoring or something that establishes during that gap that there was some expectation from plaintiff of reliance on Montefiore. And here there was none. Between the two ER visits, unlike the cases cited in the brief, there was absolutely no contact between plaintiff and Montefiore. She did not return to the emergency room, nor was she ever told to return to the emergency room. She made no inquiries or requests for copies of the CAT scan. There was absolutely nothing during that time until there was 28 months after the first visit to the ER, a second visit to the ER. And I refer the court respectfully to this court's decision in Chestnut, where the analysis really focuses on, in a failure to diagnose case, there still has to be, was there consistent treatment or monitoring during that time? Any connection to Dr. Garan that appellant argues is of no moment because he had nothing but his only connection to Montefiore was he had privileges, and under the cases cited in the papers, that is not sufficient nexus between Dr. Garan and Montefiore to impute anything he did or did not do to Montefiore for purposes of this analysis.
Okay. Does anyone else have any questions?
No.
Okay, thank you. Mr. DeJoseph, you have 2 minutes to rebut.
Briefly, I'll just say this: what we're gonna do here is just stick our head in the sand and say, hey, listen, the fact that she was treating at Montefiore for the exact condition that she went for it in October, in February, and had surgery there and was under a course of treatment, well, because there's the gap, okay, maybe this case is special, but that gap should not disqualify the plaintiff as a matter of law. That's for the jury to decide whether or not it was a question of fact. It isn't for the court, and that's the plaintiff's position. Thank you, Your Honors.
Okay, thank you both.
Happy New Year to everyone.
Happy New Year to you.
Happy New Year.
Thank you very much.
Thank you, cousin.
The next case is People versus Brian Quattrochi.
May it please the court?
Sure.
Barbara Zolot for appellant Brian Quattrochi. I'd like to address the charge point that was in point 2 of our brief and the subject of our reply. Your Honors, in this case, over defense counsel's repeated objections, the court instructed the jury as to when a police officer is justified in using deadly physical force against another. That charge was error, as it injected an irrelevant issue into the jury's deliberations that risked confusing them and distracting them from what they really needed to do, which was decide whether the evidence established the elements beyond a reasonable doubt. This police justification charge was completely unnecessary here because defense counsel never put the legality of the police shooting of my client into issue. There really can be no dispute about this because the court acknowledged that when, after summations, when it was wavering as to whether to give this charge or not, the court acknowledged that neither side had addressed the legality of the police shooting in summations and had cast it only in terms of credibility. The court then inexplicably decided to give the charge over defense counsel's cogent objections. The court was absolutely right, though, that defense counsel had not put the legality of the shooting into issue.
Well, let me ask Ms. Solot, even if we were to agree with you, because nobody had addressed this in summation, that it was not necessary for the court to give such an instruction, wouldn't we be able to say that this was a harmless error, given that the evidence was overwhelming, that the defendant trapped the victim in the apartment and stabbed her repeatedly? And it's only, you know, I guess by fortune that she wasn't more seriously injured as a result of that.
No, Your Honor, because that's not the full harmless error analysis. That is the first step. We could disagree about how overwhelming the evidence is, but there is a second step to the harmless error analysis, which is, did it have a significant probability of making a difference? And of course, the charge error itself has its own prejudice analysis, which is, might it have confused and misled the jury? And all of that is established here. And that's because this case presented the very real risk that the jury would, that because of this charge, the jury would shift its focus from the analysis you said, does this evidence prove his guilt, into simply shifting the jury's focus into assessing the conduct of the police. This was a complicated set of charges. The jury asked numerous questions over the course of 3 days. There was a kidnapping charge here. These concepts are not easy, and the jury asked about it quite a bit. But at the end, one of the jury's final questions was to ask what led up to the shooting in the bathroom and why might Quinn, who was the shooter, have discharged his weapon, which presents the very real and non-speculative risk that the jury had sort of thrown up its hands at that point. This is really all very confusing, but if we find that Quinn was justified in shooting Mr. Quattrochi, then he's guilty. You know, kind of did a backdoor analysis and a shortcut. And the jury's questions here present that very genuine concern, which is separate and apart from the strength of the evidence. The jury here might have decided the case on a different basis. And that was defense counsel's concern. I mean, defense counsel said, we'll never know. The jury may be distracted from the elements and instead be focused instead on the police conduct. So under this rather unusual case, and given the jury's deliberations, we can't say it was harmless. If there are no further questions on that issue, I'd like to address sentence briefly.
Okay, why don't you do that briefly? You have a minute.
Okay. The sentences here of 23 and a half years on those counts, we asked the court to reduce those sentences. There is no question this was a serious crime against a vulnerable victim. But even with that, the fact remains is that Ms. Picardo, perhaps by fortune, but she was not seriously injured. She left she was ready for discharge the next day. She stayed a day longer for other reasons, but she was ready the next day, and she got over-the-counter medication. That 23 and a half year sentence, a sentence for murder, the maximum would be 25 to life. And he got the minimum of that maximum sentence when no one was killed or even seriously hurt. There's mitigation here. I mean, he said to the probation department, "I lost my mind." And this incident really suggests that that's what happened, that this man freaked out. He thought the police were coming for him. He freaked out. He did not act in a premeditated way. He has a lot of trauma and mental health issues in his background. He was not equipped to deal with this. He did not have adequate coping mechanisms. He was very seriously injured himself. His wife died. Sentences of 12 years would promote the same purposes of punishment here. Those are lengthy sentences.
Okay, you'll have a minute or two for rebuttal, so can we hear from the people, please?
Thank you.
Thank you.
May it please the court, Victoria Muth for the people. The court did not gratuitously charge the jury on justification of police use of force. The only reason that it went into the charge was because of the defense arguments that the police had a motive to lie because a weapon had been discharged. Once the jury heard that argument, they were entitled to have a yardstick in the form of an instruction by which to evaluate that defense. The jury still had to make a credibility determination, and this charge simply gave them a tool by which to do that. So having raised the issue, defendant having raised the issue, the charge could only have assisted the jury and not confused it. On its face, the charge made clear what the people's burden was. It outlined all of the elements of the crimes with which defendant was charged, and it explained how to make credibility determinations of all of the witnesses who had testified. Additionally, the jury had been extensively voir dired before being impaneled on exactly how to evaluate this evidence that an officer had discharged his weapon. In fact, one potential juror was even discharged for cause because she said that that if she heard evidence that an officer discharged his weapon, then she would find defendant guilty. All of the jurors agreed that they would not undergo that line of logic. And at the end of the day, whether the charge was relevant or not, it could have had no impact on the verdict. The jury heard the victim testify about what defendant did to her, and defendant concedes as much on appeal and really only challenges the intent element of his crimes. It would defy logic to say that the jury could not come to a proper conclusion and separate an arguably irrelevant charge from defendant's criminal conduct. Turning very briefly to the sentencing point, the presence of mitigating factors is neither unusual nor justification for reducing defendant's sentence. Defendant is a violent man, and justice is not served by lowering the sentence for a repeat violent offender who tried to kill a defenseless victim. Unless there's any questions from the panel, I ask that the conviction be affirmed.
Oh, okay. Thank you, Ms. Solot. Any rebuttal?
Yes. My adversary is just wrong that defense counsel somehow opened the door to this charge. What defense counsel did was a classic credibility challenge in which defense counsel cataloged the inconsistencies and the implausibilities in the accounts of the complainant in particular and the police officers to argue that the prosecution didn't carry its burden with credible evidence. Counsel disavowed that it was making any challenge disavowed to the jury that it was even challenging the legality of the shooting, and said even if they shot first and asked questions later, which was one of the defense hypotheses in summation, that wouldn't be wrong because he was a big guy with a knife. The only way the defense was using this NYPD investigation into shootings was to say it would give any officer a motive to stretch the truth or not tell the whole story because, of course, regardless of how the shooting went down, good, bad, or otherwise, the police officer would want to cast his actions in the best possible light. The kinds of what defense counsel was saying, and I pinpointed one of the arguments in summation, was if they are being dishonest with you about the way it went down, how can you believe anything they say? He wasn't saying acquit my client because the police were not justified in shooting him. That was never uttered or even hinted at. It's that these police officers are not believable, and so globally, you must find reasonable doubt. How that could have necessitated a charge about that invited the jury to decide the case on the basis of whether the police were justified or not just does not hold up, nor did the court ever tell the jury, this does not change what your burden is, what your duty is. Did not say after giving that irrelevant charge, which should never have been given, but this should not distract you from your task. So the jury, they didn't know. They could very easily have turned to it to assist them in deciding this complex set of charges.
Okay, well, thank you very much. I think we got the argument. We'll take a look. Thank you both very much.
Thank
Have
you.
a nice day. The next case for argument is Nation Star Mortgage. Okay, the appellant, Mr. Bridie.
Friday, good afternoon, Your Honor.
Good afternoon. You may start.
May it please the court, appellant's argument will focus on the IAS court's dismissal of the plaintiff's declaratory judgment claim. As to the remainder, we stand on our papers, subject to obviously any questions the panel has and the need to address defendant's arguments, and as indicated by the court, we reserve.
I was wondering,
yes.
why do you think that there needs to be a declaratory judgment claim separate and apart from the indemnification claim? What do you get from that you don't get? I mean, very often declaratory judgments are duplicative.
Understood, Your Honor, and I can go through the reasons why they're duplicative. To get to the specific question of why we need it, there's an outstanding dispute, in particular with respect to the continuing indemnification obligation under this contract. There's a dispute as to whether there's an obligation to continue to indemnify Nation Star, or rather defendant's obligation to continue to indemnify Nation Star beyond the 5-year sunset provision in the contract. I think to best epitomize Your Honor's question, there's an aspect of the IAS court's holding that says, hey, you can't have an indemnification claim under count 1 if you haven't incurred the losses because they're otherwise speculative. Well, if that's true, Your Honor, we are then entitled to declaratory judgment, making clear that for the notice claims, we are entitled to that remedy for a timely notice claim that the obligation continues. And when those losses are crystallized, we can make that claim. So that, Your Honor, is why we need it. That obligation.
So let me ask you something. It's my understanding that Judge Cohen dismissed that portion of your contractual indemnity claim, which dealt with future losses. He said that was dismissed with prejudice, right? So he said you were not entitled to future losses. If you were entitled to future losses, if that was a possibility, why couldn't that be within the context of the contractual indemnification claim? And why does it have to go separately into a declaratory judgment claim?
So, Your Honor, just to clarify, respectfully, what Justice Cohen held, our understanding was that you're not allowed to recover future losses that are speculative or uncertain and haven't been incurred. That was the limits, metes, and bounds of his order. And what does that mean? Well, that means what he also, by the way, left specifically open in his decision after argument makes clear. He says there's going to be judgment calls down the road. What's a future loss? What's not a future loss? Okay. So, in terms of at the macro level, Your Honor's question, the declaratory judgment claim, I would submit to you, if you agree with Justice Cohen that future losses, you cannot pursue them in our count 1 indemnification claim for damages until they can be calculated with reasonable certainty. If you conclude that, then by necessity, our claim is ripe. It is not duplicative. It is live and manageable as to the continuing obligation with respect to notice loans. So I think, we disagree with the kind of, and the primary reason to note, Your Honor, the disagreement with respect to the future loss component of Justice Cohen's holding is that it seems premature to make determinations. It's that aspect of what's premature or not. To say these are future losses under a contract, I think at this stage before the factual record is developed, I think that adjudication was premature. But even accepting it is correct, then that just necessarily means that the declaratory judgment that we seek is not duplicative. And the grounds on which he dismissed the declaratory judgment claim is that it was duplicative and unmanageable. And on both, excuse me, yes, Your Honor.
No, go ahead.
No, and I was going to say, and on both of those scores, you know, we would submit, you know, in the briefing we articulated and identified, you know, manageability was an issue that he frankly brought up in the hearing, and we addressed. It wasn't a grounds, you know, on which the defendants argued, hey, you can't have this claim, it's going to be crazy. I would submit to the court, and we identified 3 aspects of what could happen at the end of, you know, the evidence that's adduced. Certainly in play and in our complaint, we asked for a declaration about the obligation with respect to notice loans. Certainly that's a manageable declaration. That's a question of the contract construction that the parties obviously dispute. Then incrementally, there can be loan by loan declarations. You could bucketize them. But at the end of the day, Your Honor, our primary problem and sort of the nub and the essentiality of this appeal is around the sweeping nature and the dismissal with prejudice and what that connotates. We simply believe, you know, when you take in the commercial realities of this transaction, the provisions, you know, most saliently 701 and 704, and especially Justice Cohen's recognition on the record, where he actually specifically says, Your Honor, he states there may be a close question or maybe a question about whether 701 is designed to let you make a claim, even if losses incur later, but that's not in front of me now. And that's in A53 of the record, line 44, 20 to 23. What does that say? That says, hey, we got a live controversy here. Hey, we got a dispute between the parties here. And so a declaratory judgment that speaks directly to that component, you know, assuming arguendo he is correct, that says, you know, our view of his actual loss holding is that all it actually says is that, hey, Nation Star, if you come to the table, you better be able to show out-of-pocket losses that are gone, you know, and you ain't getting back in order to demand the counterparty pay for them. Fine. Okay. Oh, yes, Your Honor.
Okay, can you finish up, because we're gonna go to the
I certainly can, Your Honor. Just briefly, the 3 reasons basically why we believe the declaratory judgment holding and dismissal was an error. 1, it's inconsistent with the terms of the contract. I outlined it before. 2, it's inconsistent with the judge's own order. And 3rd, just to note briefly, the Court of Appeals holding in remit. And we think the survival of an indemnification obligation, that court was faced with a very similar language that basically said, hey, if you get the notice beforehand, the indemnification obligation continues. And that court said, hey, injunctive relief, if they overturned the 4th Department and said, hey, you can get a declaration on that as to future losses. And if the court has nothing further, Your Honor, thank you for the time, and I'll reserve my rebuttal time.
Okay. Who's the first respondent to speak?
James Wicks, Your Honor.
Okay, Mr. Wicks, go ahead.
Good afternoon, Your Honors, and Mr. Briotti. So all of what's been argued here could have been negotiated at the negotiation table for this agreement. What's happening here is they're looking for a shortcut. And what do I mean by that? 27,000 loans were transferred. What's in the complaint? 27,000 loans. They have a 605-page table that lists every single loan, and they list 6 broad categories of claims of losses. What's the problem? Admittedly, these tables contain loans that have already been paid, disputes resolved. Admittedly, contain de minimis losses, which are not covered under the agreement. And the critical component is it adds a placeholder, is what I'm going to call it, for future losses, which are not allowed under this agreement, and which distinguishes it from the Remit case that they rely so heavily on. Remit, of course, Your Honors, it was an environmental contamination indemnification. It was designed for future losses. The language there is different. They use the phrase liabilities, which is not used in the indemnity here, although it's used in other portions of the agreement as well. Dismissal of the declaratory judgment, I'll focus on that for my brief time only because Mr. Briotti did, and that's the main part of his gist of his brief. Entirely appropriate. Your Honor, Justice Kapnick, you asked, why do you need a declaratory judgment? They need it because it's a backdoor for future claims. The agreement is clear, and it's been briefed heavily both below, and that's in the appendix, as well as on appeal here. They can't get for future losses. These are sophisticated parties, Judge. In fact, NationStar is probably among, if not the largest servicer of these types of HECM loans. They know what they're doing. They had sophisticated counsel in negotiating this, yet there's no language about future claims or future losses. In fact, everything in the agreement, as Justice Cohen found, supports the finding that they're actual losses. That's a defined term. It has to be an actual loss, a pending claim. Instead, you've got all of them listed, and Justice Cohen honestly gave them an opportunity to clean it up. He says, maybe there's something here, so you can replead, but you can't have a DJ and an indemnity breach of contract. You've got an indemnity claim. You know, there's an exclusive remedy provision, which we haven't discussed and which is in the briefs. Also, NationStar, this is the second NationStar case, by the way, over this agreement. There was an earlier one before Justice Schechter. She, too, found this exclusive remedy clause barred other types of claims. It's an indemnity claim. That's all we have here. So in sum, this is really something that should have been negotiated, could have been negotiated. In fact, it was negotiated. And that's how you arrive at the price that was paid for these and the loans that went out. So there was no intention of any of the parties, there's nothing in the agreements to suggest otherwise, that this was going to go on forever or indefinitely. And there'd be no end in sight for the losses that are to be paid. And that was never contemplated. So unless your honors have any questions for me, I'll defer to my colleague, Mr. Gagan.
Okay. Thank you very much, Mr.
Thank you.
Wicks. I assume nobody has any questions unless you know, we're not usually shy about questions. Okay. May I hear from the attorney for Guggenheim?
Thank you, Your Honor. Martin Gagan from Winston & Strawn on behalf of Respondent Guggenheim. I actually want to pick up on a point that you made, Justice Kapnick. You are correct that Justice Cohen specifically found on December 6, 2019, that any indemnification claims for future losses were in fact dismissed with prejudice. And contrary, respectfully, to Mr. Brody's statement, that issue was not left open below. And specifically following up on Mr. Wick's comments here in terms of what this purchase agreement says here. It's not just the definition of losses, which Mr. Wicks pointed out, which specifically includes only actual incurred losses. It's not only the specific prohibition against speculative or remote damages under Section 705. There are two other provisions in the purchase agreement that make clear that NationStar is not entitled to seek any future losses for indemnification after the 5-year anniversary of the closing date, or May 1st, 2020. And specifically, Your Honors, it's Section 702 E1D and Section 702 F1. And specifically, Justice Cohen found that the definition of losses combined with the prohibition against speculative or remote damages under Section 705 shot right through the eyes of any claim for future losses.
Well, I thought that part of the argument here was this deals with reverse mortgages, which is a different animal than other mortgages and whatever. So the argument that it seems to me the plaintiff is making is that even if, I mean, speculative damages, I understand, but if there have been within the 5-year contractual period, but there has been some kind of a damage claim, but the actual damages have not been suffered until after the 5-year period, isn't that what he's saying? Those should be left in until we figure out exactly how much they are, but we know they're coming because of the nature of this reverse mortgage type of a product.
Well, Justice Kaplan, you're exactly right. That's what NationStar is saying
Right.
But the problem is, Your Honor, that's not what the purchase agreement says. And this goes to the nub of this. We're in month 22 of this litigation here. We're still at the pleading stage here. And the point is this. NationStar is a highly sophisticated corporate entity, one of the largest mortgage servicing companies in the country. Your Honor, if it wanted to negotiate and to provide for provisions that it provided for indefinite indemnification liability into the future, it certainly could have. But to accept that interpretation, Your Honor, here's the problem. Then you need to read out the definition of actual losses. You need to read out Section 702A. You need to read out Section 705. You need to read out Section 702E1D, and you need to read out Section 702F1. It just doesn't work. They weren't able to negotiate this 5 years now, and they're asking this court to obtain contractual concessions that they couldn't obtain 5 years ago at the negotiating table. And I know my time is short, Your Honor, just very quickly on this business on Section 701, which is the underpinning of NationStar's argument here. There's a critical difference between Section 701 and Section 702A. Section 701, Your Honor, is a notice provision. That's an indemnification notice specificity provision. Section 702A is the source of defendant's indemnification obligation, not 701. And how do we know that? If you actually take a look at Section 702A, it specifically provides for indemnification obligation, which in turn is subject to the notice provision here. So the bottom line here, Your Honor, is reading Section 702A in harmony with the other four provisions that I just mentioned makes it clear. The purchase agreement provides for only actual incurred losses before May 1st, 2020. Thank you, Your Honor.
Thank you, Mr. Gagan. Mr. Brody, you have 2 minutes to respond.
Thank you, Your Honor. Very, very briefly, and I'm not going to bury the lead here, Your Honor. There's been a lot made about what could have been negotiated and sophisticated parties and when. Generation was in the servicing business before this deal was negotiated, but that's not germane here. Both parties were sophisticated, and what is nowhere in this contract is any verbiage that says exactly what the defendants are urging incorrectly that Justice Cohen said or what they want this court to find. And that is, there's nothing in this agreement that says your obligation to indemnify us full stop ends at losses at 5 years. Doesn't say it anywhere. And in fact, it says the opposite in 701 and 704. And if you abide by what defendant's construction is, what in fact you'd be doing is reading out the notice provision and significance in 701. 701 says, and I'm going to ellipses out, please indulge me with the time, but notwithstanding the foregoing, a specific pending claim for indemnification for which the requisite notice was given on or prior to the particular survival period set forth above, with sufficient information and documentation to establish the basis for the claim hereunder, shall be deemed to fall within the survival period. Then you read that with 704, which itself says, as to any claim for which notice is given, as hereinbefore provided, the corresponding obligation of indemnity shall continue to survive until it's paid off, resolved by a court, or liquidated. And this is A182 of the appeal. What they are saying is those provisions are totally meaningless, totally meaningless. All this nonsense about losses or a claim being deemed to fall within a 5-year survival period, just nonsense. They just put it in there for no reason. And I want to take, Your Honor, because I want to meet head on the provision that defendants cite frequently, which is 702D. And what 702D, 702T bolsters our position. It says for any losses for which notice was given by purchaser to 1 day after the 5-year anniversary of the sale date, the purchaser indemnity shall not be entitled to collect any amount from the seller. What does that mean? If you gave them the notice before, you're still on the hook. That's what that language means. And it's the only reading of the contract that's consistent with 701 and 704. So I know my time is short, Your Honor, but I do want to note one other thing. With respect to 702E and Mr. Wick's representations that there's no end in sight, 702E includes a cap. If you look at the provision, it includes caps on liability by the defendants based on when notice is given. So what was negotiated here? What was negotiated here was a surviving indemnification obligation, and the defendants got a cap, and they got the right to know how big the bread box was before the 5-year limitation when they got notice.
Okay,
Thank you, Your
well,
Honor.
we will take a look at those various sections. Thank you all for your time and for your arguments. Have a good afternoon.
Thank you, Your Honor.
Happy New Year.
Happy New Year.
Same to you.
May I, the next case for oral argument is Narvaez versus the city.
Good afternoon, Your Honors.
Good afternoon. You may proceed.
Thank you. Valerie Prezimenter for Everest. Our position is that the lower court here improperly denied Everest's summary judgment motion when it conflated the duties for inspection of this bridge between those of DASNY and the city defendants and those of Everest.
Well, didn't your one of your, I think it was your vice president, testify that you were aware that the material, the wood used in the construction of these bridges deteriorated after a certain period of time, which had passed?
He testified that there was a possibility of normal wear and tear, as all sidewalk bridges have, because it is wood material that's open to the elements. But it is the responsibility of the owner. I think in this
instance, he said it was untreated wood. Ordinarily, when you do things outside, you use treated wood, which lengthens its lifespan. This was untreated.
But here, the owner had the duty to do visual inspections and inspections of that. And if there was an issue, which nobody ever contacted us about, then we would have come and made repairs as needed. We put this bridge up 7 years before the dates of these incidents. During that time,
and your claim is that you have absolutely no responsibility as the the company that constructed this bridge and that owns this bridge to ever check it out while it could be there for years and years and years, unless you get a notification from somebody else?
So in addition to the fact that the building code says that the owner, in the absence of a contractor performing active work, is required to do visual inspections of the sidewalk bridge at the premises, we specifically contracted here that inspections were the duty of the contractor. And that is a duty that can be delegated by the law to the person who is in a better position to do so. Everest, just like every other sidewalk bridge contractor, they put up hundreds of thousands of these bridges around the city. It is not practical and not possible for them to be constantly going and inspecting them. That is why that is delegated to the owner, who's in a better position to be able to go and see whether there's any need for repairs, whether to call Everest to come back and do any kind of repairs. They are there on site. They are the ones actively performing the work. And if there's any issues, they are supposed to notify Everest. And in this case, the contract specifically said that they're required to do inspections of that bridge. And in this case, they did not do so. That's pretty much our position. The sole responsibility.
Did you have any additional responsibility each time you entered into a lease with a new company to make sure that it was that the bridge was okay at that particular time? Do you believe that you had a responsibility to do that? Because first there was Coates, who's not a party, and then you leased it to DASNY, and I know there's some question whether Hostas ever signed the contract, so we're not even sure who was responsible. But could you just did you just sort of walk away from any responsibility to stay up there for 100 years? You'd never be, never have to check it out?
Well, our responsibility was delegated to the customer. The customer is in the best position to do the inspections. If they feel there's an issue, they can call us out and we do the inspection. But there's no responsibility just because the ownership changes. It could change 100 times. We are not required to go back and inspect based on actions of a different party. Now, here, that's the main issue here, whether the duty to inspect was between Hostos or DASNY. But that's irrelevant to Everest's duties, because DASNY admitted. Sorry.
Wouldn't that be something between you? I mean, when I say you, I mean Everest and Hostas or DASNY, and not between you and the plaintiff. I mean, the plaintiff has no idea. All they know is that it's your scaffold. You put it up. How would they know that they're supposed to, simply go after someone else if they get injured when you put it up? You put up your scaffold. You built it with not untreated wood that, according to your own witness, was only going to last at most 5 years, correct?
Well,
so what's the remedy then to this plaintiff here when they get injured because your scaffold all of a sudden falls apart?
Well, I would disagree with the all of a sudden falls apart, because also under Espinel, the plaintiff here has to meet a certain threshold, and he has to show that Everest displaced that owner's duty to maintain the premises and this sidewalk shed. There is specific concrete evidence here in the form of the contracts showing that Everest did not displace that duty, that it specifically delegated the inspection duties of that bridge to the owners, who again are the ones in the best position.
You entered into a couple of different lease agreements with different parties, is that correct?
We entered into first an original lease agreement with Coates, and then there was an assumption and a takeover contract, excuse me, with Dasney, who took over the original.
Did you have any obligation when the contract was assumed by the other party to make sure that what you were handing over to them was in good and adequate, reasonably safe condition?
We did not, because it was already at that point a lease. It was already a rental piece of equipment that was already in the hands of Coates. So it was Coates' responsibility to make sure that when they were handing over the entire property, that bridge was in good and sufficient condition. And it was also the duty of the party assuming the contract to make their inspection. And if they found a problem, as the contract states, to call Everest and have us come and do those repairs. They're the ones assuming the lease.
Okay, you'll have 2 minutes for rebuttal. May I hear from the attorney for the City of New York, please?
Yes, Your Honor. Should the plaintiffs go first?
Well, I don't know. I thought you should go first, but what do you think?
If that's your preference, Your Honor, sure.
Yeah, why don't you go first?
Yes, Your Honor. Daniel Matza-Brown, Assistant Corporation Counsel for CUNY and the other city respondents. Supreme Court properly granted summary judgment here because there are triable issues about the parties' meeting of the minds and what they agreed upon.
They denied summary judgment.
So, yes. They properly denied summary judgment because there's a factual dispute about whether there was a meeting of the minds as to who should inspect the scaffolding here. The position of Everest as to the contract here is that when CUNY said to Everest, we're taking over the scaffolding, we want to pay you, CUNY said to Everest, send us the terms and conditions. Instead of sending the Dasney contract that Everest now claims CUNY is bound by, which it never sent to CUNY, Everest sends a new contract, which CUNY refused to sign. CUNY did not sign the contract that Everest proposed. Everest now claims that CUNY is bound by a contract, not only a contract that it did not sign, but a contract that it never even saw. Right? The notion that summary judgment is granted in Everest's favor on that grounds, strange credulity. They also point to supposed course of conduct by the parties. That, again, does not show that they get summary judgment as to the parties' understanding of what their obligations were. They point to the fact that CUNY a few times noticed some obvious glaring problems, such as vandalism, and alerted Everest. Right? That does not show that any of the parties here believed that it was CUNY's responsibility to inspect the structural soundness of the scaffolding.
Well, so are you saying she's wrong that she builds the scaffold, you're the owner, you're there, they put these scaffolds up all over the city of New York. They are not going to go around and inspect them. They say they don't have the obligation. You're there. Now, I know there's some question as to whether Dasney ever turned it over to you or it's their responsibility, but they don't have the responsibility. That was a delegable duty, and they delegated it to you people on site, not to them to come out and inspect it. Unless you tell them that there's a problem, then they'll come.
First of all, Your Honor, they did not delegate the duty, right? Because there was no contract. There was no agreement on that point. But second of all, on the building code, which Everest raises for the first time in the reply brief, they're simply wrong. I submitted a letter yesterday to Chambers.
Yes, we got that. Thank you.
And section 3307.6.5.8 is called periodic inspection. And what it says is 6 months, every 6 months after the installation, a person designated by the designer or permit holder, both of those entities are Everest here. So Everest had to designate a person to every 6 months inspect the scaffolding for precisely the sorts of problems that caused the plaintiff's injuries here, right? So they had that duty. They did not delegate it by contract to CUNY, and therefore, as a matter of policy, as a matter of contract interpretation, as a matter of the building code, they were responsible here for these injuries. And they certainly have not eliminated any triable issue as to that question.
Okay, anyone else have questions? All right, now we'll hear from the plaintiff, Mr. Fine.
Thank you, Your Honor.
Good afternoon. May it please the court. Aaron Fine for the plaintiffs' appellants. What's been recognized by this court many times over, especially in these specific cases, it is the scaffolding companies, in this case, Everest burden to establish that when they construct the structure, they have to establish that it was done so in a non-negligent and reasonable manner. And as stated by this court in Ryan, that has to be accomplished through proof of inspection. So if I may.
I'm sorry, Judge Mazzarelli here. I thought we weren't talking here about the construction, more of the maintenance and what the condition was as time went on.
Right. So it's two alternative arguments. The argument that it was constructed poorly is because it was constructed in a way that it was allowed to reach this point where it cannot withstand weather. As mentioned by Mr. Silberman, plaintiff's expert, the purpose of these scaffolds is they're supposed to resist wear and tear and weather, the exact conditions that cause this accident, high winds, rain. It was constructed in a way that it was allowed to result in this situation. But that being said, as moving on summary judgment, it was Everest's burden to meet its, it had to meet its prima facie burden that it was constructed in a non-negligent manner through proof of inspection. If I can respond to appellant counsel who said once I don't want to put, misquote her, but to paraphrase, just once their duties regarding inspections were complete, then the duty went on to the lessee, but there was no proof that Everest conducted any inspections. But that being said, it is argued that maintenance, negligent maintenance and repair, it was a proximate cause of these accidents. The only issue in why Everest may not be liable is if there's a finding that the Everest did not owe contractual duty, which the lower court respectfully submitted, found that Everest failed to meet their burden in establishing so. You have three different defendant entities. I know the city defendants is more than three, but they're all pointing the fingers at each other in terms of if there was a contract and what does the contract say. That being said, there's clearly an issue of fact as to who owed the contractual duty to maintain the sidewalk bridge. Again, if I can respond to the Espinal argument, it's respectfully submitted that that Everest has it backwards. Everest is the owner of the scaffold. It's their duty to establish that whoever, whether it was DASNY or Hostos, they're the ones who were supposed to have to establish displaced Everest duty to maintain it. And again, the fact is that all the parties are pointing fingers at each other. There's clearly an issue of fact as to who owed the contractual duty to maintain it. And just one more point, in terms of Mr. Delgado's accident, there's clearly somebody made a repair to the scaffold. Again, nobody is pointing fingers. Nobody's saying who did it, who didn't. Again, that's raised an issue of fact as to whether launching an instrument of harm and creating the defective condition. Everest cannot point to, in terms of Mr. Delgado's accident, that they didn't negligently repair the scaffold.
Okay, thank you, Mr. Fine.
Thank you.
You have 2 minutes for rebuttal.
Thank you. As much as I hate to waste my rebuttal time on arguments made by the city today about the letter that they sent yesterday, the only reason that Everest put into its reply that building code information is because they, for the first time on appeal in their opposition, raised these public policy arguments. But they're actually incorrect in interpreting that building code violations and codes in general, because section 3307.6.5.3 says that sidewalk shed shall be maintained and used by the general contractor. And when there is no general contractor, the contractor performing the work, or where there is no active work, the building owner. So them citing to the building code harms them, because that same code says that they are the ones who have the duty to perform these inspections, to make sure it's maintained, to contact the sidewalk bridge installer, because again, 3301.4 of the building code, which again is not in the papers because they just raised this the other night, says that it shall be inspected by a competent person designated by the contractor using the equipment. Here, just because they had nobody performing any work for which this bridge was erected, all it does is shift that duty to the owner themselves, regardless of who that owner is. Now, just since I only have a minute left, going back to plaintiff's argument, there is no evidence that this was poorly constructed when it was put up. The only evidence plaintiff supposedly puts in is their expert, who should never have been considered by the lower court because all he did was look at photographs. He never inspected the subject bridge.
Well, that could go to the, I mean, that doesn't necessarily go to the admissibility, may go to the weight of his testimony, but he's allowed to look at documents and give an expert report from that.
However, those opinions are completely unsupported by anything because he looked at photographs from years after it was put up. And more than that, here it was inspected and approved by the owner codes after it was erected. And 5 days after erection, as the contract says, it's deemed accepted. It was deemed accepted by them.
All right. I think we got all your arguments. I thank you all very much. We'll take a look at this. Thank you for your time and have a nice day.
Thank you.
Okay. The next case for oral argument is Hadid versus City of New York. Mr. Smith, you have 5 minutes.
Yes, may it please the court, Nathaniel Smith for petitioner appellant Bobby Hadid, who is a former police officer. And the question generally for the court is whether or not Mr. Hadid had earned vested retirement benefits. The second department reversed his perjury conviction. The decision's in the record. And pursuant to the certificate of disposition, the arrest and the prosecution shall be deemed a nullity, and the accused shall be restored in contemplation of law to the status occupied before the arrest and prosecution.
But wasn't there also a requirement that before that happened that there be a hearing with the police department, which there was, and they found differently?
Well,
wasn't that part of the process?
There are two issues. One is what are his benefits, if any, under the retirement plan with the police pension fund. And the other issue is, as Your Honor probably is aware, under the Public Officers Law, Section 30, if somebody is a public officer and he's convicted of a felony, his office is vacated as a matter of law. And for many years, that was the law until the legislature fixed a little loophole and said, well, if there's a conviction, but it's reversed on appeal, then the accused can apply to have their job restored. And Mr. Hadid did do that. And ultimately, the police department, after litigation and many other years of things happening, they denied his application for reinstatement. So the issue here is not about whether or not he should get his job back. That's already been litigated and lost. The issue here is whether or not he should be restored to the status that he had before his conviction. And what he says and what I say on this appeal is that he ought to be able, based on an equitable notion that forfeiture should not be permitted, that he ought to be restored to a position so that he can receive his vested pension benefits. The pension fund says under the administrative code, you had to have submitted 30 days before your discontinuance of service an application for vested benefits. And you didn't do that, so you're out of luck. What we say is that under the New York Retirement and Social Security law, he is entitled to a vested benefit because that statute specifically provides a member who discontinues service other than by death or retirement shall be entitled to make application pursuant to Section 75 of this article for a vested retirement allowance to be effective on his 60th birthday. And it goes on, the retirement allowance provided by this section shall vest automatically upon such discontinuance of service by such member. ultimately, I think what really the question for the court here is, should a mechanical application of the administrative code provision apply, or should provision 76 of the retirement social security law apply? You know, I have laid out in my briefs why I thought, and I still do think, that this police officer did a very good job and was very successful as a Muslim Arabic police officer who got tangled up when he started asking questions of his superiors about why they were targeting Arabic speaking and Muslim speaking people. And that was the beginning and the end of his career. And there's extensive litigation. I was involved in it in federal court trying to assert his rights. That's all done. It's gone. I understand that. But the question here is, since his perjury conviction, it was a perjury trap. Frankly, if you read the decision by the Second Department, it's clear. This was not a perjury, and this was not a crime of moral turpitude. It was nothing. It was actually a simple mistake that witnesses make every day in courts and in depositions throughout the land, but it was converted into a perjury charge that was insufficient as a matter of law. And so what we're saying is that once his conviction was reversed under the CPL, he's entitled to be restored to that situation, and he ought to be given the opportunity to apply for and receive his pension benefits. Section 76 of the retirement social security law gives him that benefit. I don't even know if the one that the lower court relied upon even applies, because it just on its face doesn't make any sense. His office was vacated as a matter of law under the Public Officers Law, Section 30, when he was convicted of a felony.
Okay, can you finish up, and you'll have 2 minutes for rebuttal.
No, that's all I want to say. Frankly, I'll wait for rebuttal. Thank you.
Okay, thank you, Mr. Smith. Can I hear from the city, Ms. Brenner?
Yes, Your Honor. May it please the court, Deborah Brenner for the respondent city and PPF. There are 2 primary points, some of which have already been made by my adversary. The first is that he has conceded that a mechanical application of the statutes, both the administrative code provisions and the public officers law, support the determination here denying him his vested.
Councilor, if I may, please, just explain to me. The administrative code provision that's at issue here would require that he file his application for pension benefits 30 days prior to the discontinuance of service.
Correct.
In this instance, where the discontinuance of service occurred because of a conviction, how would the petitioner be able to do that? How would the petitioner fairly be able to comply with that provision?
Well, there are several ways, Your Honor. I mean, first of all, the record here shows that the termination did not happen overnight. Mr. Hadid was well aware that he had been placed on modified assignment. He was also served independently of the perjury and the circumstances surrounding the perjury with disciplinary charges having to do with
If I may, I don't mean to interrupt you, but if I may, there seems to be a presumption on in your answer that anyone who gets indicted, who is a police officer, better retire because they have to assume they're going to get convicted.
No, Your Honor, I don't think that's the case. But if they haven't attained 20 years of service, which is the very narrow exception that the legislature gave to only those officers who have attained 20 years, and they want to be certain to keep their vested credits, they can basically take their marbles and go home. They can say, I'm not going to wait for the outcome of this proceeding. I'm going to put in for retirement. And the statute says 30 days before effective date of retirement. It does not say before the effective date of discontinuance. So you have to opt to retire, and you have to do it 30 days ahead of time. Put in the application 30 days ahead of that date. So I think, the problem for Mr. Hadid is that the legislature has foreseen this exact situation, and so has this court really.
I thought the statute said 30 days before discontinuance.
No, it's 30 days before the effective date of retirement, I believe, Your Honor, if I'm not mistaken. Which makes it very clear that the officer must make the affirmative choice to retire and put in an application as well.
In this instance, he believed he wasn't guilty and his conviction was reversed.
Yes. And that gave him a very limited right. Again, legislature has addressed this. It gave him a right to apply for reinstatement and to receive a hearing. At that hearing, which he received, the appointing authority here, the deputy commissioner, was to consider the order that granted the vacatur of his of his conviction, as well as any other, his entire employment history and any other facts that could conceivably bear upon his fitness to be reappointed to his office. There's no dispute that happened here. And in fact, there couldn't be a dispute because it would be years past the time when that hearing could be challenged in any way. So the court must accept, right, because it's not brought up by the petition. The court must accept that the findings of that hearing officer were supported by substantial evidence, not disputed, and gave rise to reason to not reinstate him, also not disputed. Without being reinstated, he cannot submit the necessary application. And that's true under the administrative code provision, which is spelled out in great detail in the Duradogan case of this court, but it's also spelled out by the RSSL. I'm not sure why my adversary continues to rely on the RSSL without addressing what we cited in our brief, which is RSSL section 70, which specifically states that an application for retirement must be made by a member 15 days before the date of retirement. And so that does not avail him in any additional way. I mean, and not under the circumstances of this case. The 15 to 30 day thing, that's could conceivably be grounds for litigation in some case, but it isn't here.
Okay.
Even yes.
Can you just finish up if you don't mind?
I will, Your Honor. I think if the court looks at the Duradogan case, which is particularly convincing here because of the way the court originally wanted to grant the petitioner in that case a similar kind of relief of allowing him to receive his vested retirement benefits, but then on re-argument realized its mistake and spelled out in great detail why the statute simply does not permit that unless you have a situation where the penalty of dismissal was shocking to the conscience. We don't have a claim of that here. The only thing that Mr. Hadid is claiming is shocking to the conscience is the denial of his pension, and that's simply commanded by the statute.
Thank you, Ms. Brenner.
Thank you.
Mr. Smith, you have 2 minutes.
Thank you, Your Honor. I think this court in the Vecchio versus Kelly decision, 94 AD 3rd, 545, shows that when it's not really clear what the statutory provisions apply are, that a forfeiture under circumstances where there hasn't been any act of outrageous moral turpitude, that the court has the power to void some sort of unfair and unjust result. And I respectfully submit to you that that's what's going on.
I presided in that case, in Vecchio.
Yes, Vecchio. That was
Wait, Mr. Smith. Let Judge Mazzarelli speak, please.
The facts were very different, and we were only dealing really with the penalty. That's what we found first to be unduly harsh, and we made a request that he be allowed to retire. He had 25 years, I believe, on the force of unblemished service, and it was a very unusual occurrence. So I don't know that Vecchio, while I can understand that you would cite it, would be determinative here.
I don't think it's determinative because I think the court's power and authority is a balancing act here. But Vecchio, the police officer there was actually guilty of taking and possessing nude photographs of an arrestee and a rape victim. And the court said that he should be permitted to apply for a vested retirement interest here. And you know, like I say, the mechanical application of this statutory provision under these circumstances is manifestly unfair because his conviction was reversed and he should be restored. The spirit of the law here is that he should be restored to the position he was in before he was ever accused of a crime. And that is what has been robbed of him here. And that's what this court has the power to give back, as they did in Vecchio. Thank you.
Thank you. Thank you both very much. Have a nice afternoon.
Thanks the court. I want to thank the court for making this available too.
You're welcome. That's what we do. Okay, the the next case is Backcourt versus the City of New York. All right, appellant.
Good afternoon. Brian Shute for the plaintiff appellant. In 2003, the City Council enacted the so-called sidewalk law, which, with the exception of certain owner-occupied 1 and 2, 3 family dwellings, transferred the common law responsibility for maintenance of the sidewalk from the city, qua municipality, to the abutting owners. The question here, in this case, is whether, in an instance where the city is being sued, not as the municipality that owed the sidewalk, but because it was the abutting owner of the owner of the property, whether it should be effectively exempt from the sidewalk law, able to hide.
So, Mr. Shute, I mean, I found your argument very interesting, and I took a look at the sidewalk law. But how do we come to your conclusion, reach the conclusion that you would like us to reach? Don't we have to ignore Administrative Code 7-210D, which says nothing in this section shall in any way affect the provisions of this chapter governing the manner in which an action or proceeding against the city is commenced, including any provisions requiring prior notice to the city of defective conditions? How do we justify?
Absolutely not, Your Honor. And what you will find is you have this ostensible conflict between the provisions of B, which impose this duty upon abutting owners, and the subdivision D, which you just read, Your Honor. I will show you that subdivision D can be consistent with that language and consistent with the law regarding abutting owner liability. That can be given meaning. On the other hand, the city's interpretation, it stands on simply ignoring the language of subdivision B. Let me start with subdivision B, and I'm going to get to subdivision D in just a second, Your Honor. Subdivision B starts with the language, notwithstanding any other provision of law. That's the phrase it starts with. The owner of real property abutting any sidewalk shall be liable, and it continues. I emphasize, Your Honor, shall be liable. It doesn't merely say shall have a duty, in which case the city could argue, well, they meant for us to have a duty and not be liable. It says, notwithstanding any other provision of law, shall be liable. The city's argument, Your Honor, of how you get around that at page 11 of their brief is that the city council must have meant notwithstanding any other provision of law except subdivision D of this provision. The problem with that, Your Honor, is that this language, notwithstanding any other provision of law, is used in thousands of statutes. And as we show at pages 17 to 19 of a reply brief, in every instance in which the legislating body meant to exempt another portion of the same provision or the same article, labor law section 772, except as provided in subdivision of this section and notwithstanding any provision of law. The judiciary law section 39, notwithstanding any other provision of law and except as provided in subdivision 3 of this section. Insurance law 8015, notwithstanding any other provision of law to the contrary, except as providing in subdivision C and D of this section. That's what you do not see here. Now, subdivision D, what you read, Your Honor. Prior to the enactment of this law, the city, of course, was responsible for all this area that's now transferred to the abutting owner. The argument could have been made City, you're now responsible, according to the testimony of your corporation counsel, then Michael Cardozo, you're only responsible for 1/3 of the accidents which were responsible before. How can you rely on the prior notice law? This protects against that. But notice, Your Honor, when you look at the language that you just read from subdivision D, it doesn't provide any new application of prior written notice law. It says nothing shall affect. Now, as we point out in our main brief, pages 49 to 52, there are 3 situations at common law where an abutting owner is responsible for maintenance of the public sidewalk. The general rule is they're not. The 3 exceptions to that general rule are A, where they create or cause the defect in issue, B, where they have a special duty or special use that makes them responsible, or C, where there's a provision, a regulation, a statute, which not only provides a duty to maintain the sidewalk, but also expressly says you shall be liable if you violate that duty. Before this was enacted at common law, prior written notice was not required in any of those instances. The Court of Appeals held in Grodner, before that in Alexander, many cases cited in our brief. The special use exception is an exception to prior written notice rules. It was before this was enacted. This doesn't purport to expand prior written notice to context it never applied before. It's a place saver. The city can use the same defense it had before. And Justice Mendez had a case December 15th decided by this court. Martin. Prior written notice law is not an exception either, where there's a cause and create argument. They are expanding subdivision D, and they are expanding it in a way that's blatantly inconsistent with the language of B, which doesn't say notwithstanding any other provision of law except subdivision D. It says notwithstanding any other provision of law. Second point, Your Honor, apart from the language of this, the purpose of this provision, according to the Court of Appeals decision in Shroom, 2019, cited on our brief, the purpose of this provision is, I'm quoting, the purpose underlying the enactment of section 2-10 is to incentivize the maintenance of sidewalks by abutting owners in order to create safer sidewalks. How incentivized was the city in this case? There are pictures, photographs of this defect that you'll find in the record at pages 1145 to 1150. What's unusual about those photographs, Your Honor? They were taken 3 to 7 years before the accident occurred. Photographs of the defect. That's how incentivized. Through this, the deposition of multiple city employees, we don't know, they don't know which department was supposedly maintaining this area because there's no proof that any department was maintaining this area. So the second point is, Your Honor, that of course, courts are supposed to consider the overall purpose of the law in construing the law. That overall purpose is not satisfied, it's not advanced by the interpretation that the city advances here. My third point.
Okay, go ahead, finish that up.
My third point, Your Honor. The Trone case, which I mentioned before, 2019 Court of Appeals, it reversed this court. It also overturned some settled decisions in this court, Cepeda Bing, where this court had held that this provision did not impose a non-double duty. The rationale, the Court of Appeals rationale for why in Trone it should apply to an out-of-possession owner in the decision by Justice Rivera was that the city council knew how to exempt owners which it wished to exempt. That conclusion it drew from the fact that it expressly exempted owners of 1, 2, and 3 family dwellings who lived there, who resided there. And the Court of Appeals reasoned unanimously that because they did not expressly exempt out-of-possession owners, therefore there shouldn't be an exemption for out-of-possession owners. I'll finish up, Your Honor. Yes. My construction is consistent, does give meaning to subdivision D. They remain they can hide behind their prior written notice law, even though they now maintain a fraction of the sidewalk they did before. Their interpretation is simply not consistent with subdivision B. Thank you, Your Honor.
Thank you very much. Can I hear from the respondent, please?
May it please the court, my name is Jameson Davies for the City of New York. Supreme Court's order granting summary judgment to the city should be affirmed. It's undisputed that the city did not have prior written notice of the alleged defect, which is fatal to the court's claim. As this court has already held on 2 occasions, Admin Code 7-210 does not change the prior written notice requirement. Fundamentally, the enactment of 7-210 changed who may be liable for sidewalk defects, but had no effect on how liability is proven and the conditions precedent and negligence claims.
Well, but I just want to ask that, does it really make sense that you would have a prior written notice? I understand what prior written notice is, but in this particular funny case or funny fact, the city is actually the owner of the abutting property as opposed to the city municipality, as Mr. Shute said, and that's the truth. So who are they supposed to, what kind of, the Department of Transportation, who usually has notice of, the prior written notice notification, why would they have it? What do they have to do with this particular property that the city owns? It doesn't really make sense, does it?
I believe it makes sense, Your Honor, for a couple of reasons. First off, the city owns the abutting property, that's correct, but the city always has been responsible. The ownership of the sidewalk is unaffected by 7-210. The city's always owned their sidewalks, and it's always responsible for the maintenance of the sidewalks, except in the new liability scheme for owners of commercial buildings that Section 210 acquired. So regardless, before and after 7-210 was enacted, the city's liability as to that sidewalk would have been the same. It's completely unaffected. And so here, it's just the same application of prior written notice principles that existed prior to the enactment of 7-210.
Yeah, but that's 17 years ago that was enacted. And the whole point, as Mr. Shute said, is that the reason they enacted it was the city felt that maybe they were getting hit with too many cases, and so they shouldn't have to be responsible for taking care of all of the sidewalks throughout the entire city of New York. So now if there was an abutting property owner, except for the various exceptions, let the abutting property owner be responsible. So here the city is the abutting property owner. So now they don't have to do it because of the abutting property owner, because there's no prior written notice. The prior written notice, I get the whole thing with the interaction of B and D and the ways it can do it, but does it really make sense?
Yeah, I believe it still makes sense because the purpose of 7-210 was to shift liability to private owners in those circumstances where they're
so here the city's the private owner.
But what my argument here is that the city is liable still. That's the fundamental way that the statutes can be read in harmony, that the 2 sections can be read in harmony. B says, notwithstanding any other provision of law, the owner shall be liable, and the city is liable, but you have to meet the conditions precedent to filing suit against the city. And that's exactly what Section D said. It says, notwithstanding, and nothing in this section shall change the way any action or proceeding against the city is commenced, including any provisions requiring prior written notice. So the city maintains its liability. And as the justices are aware, we have a lot of these cases. Sometimes prior written notice is proved, and the city in those cases is in fact liable for sidewalk defects. So the 7-210 just doesn't affect the city's liability in those cases. And I think the way the statute is written makes it clear. If they were going to shift liability without prior written notice, I think there would be some more indication in the legislative history or in the statute that this massive shift was going to happen. There's nothing pointed to in the legislative history. In fact, the legislative history, the testimony from Corporation Counsel Cardozo says, in all cases, prior written notice has to be provided to the city. Section C contemplates that the city may be liable as an owner, but Section D makes it abundantly clear, as this court has already held twice, that prior written notice requirements are not changed. So really, as I said in the beginning, 710 changed who may be liable, but it had no effect on how liability is proved. And in cases against the city, that proof of liability includes establishing prior written notice as a condition precedent to bringing the claim.
Okay. I think we have your argument. Mr. Shute, do you have any brief rebuttal?
Yes. 3 points, Your Honor. One, picking up on what Corporation Counsel just said, their construction of this provision is, as was just indicated, this imposes no duty at all on the City of New York. They'd be only liable if they were liable prior to the enactment of this provision. Notwithstanding any other provision of law means notwithstanding any other provision of law except if you're the City of New York. That's their construction. Number two, the whole purpose of the prior written notice law, the whole rationale for it, Poirier versus City of Syracuse in our brief, is that a city can't be responsible for knowing all the defects and so forth in their miles of sidewalks. Here, there is no one in better position. They are the abutting owner. There's no person on this earth who is in better position to fix this than the City of New York.
And what wasn't there testimony in this particular case or evidence that there was a guard house
3 flags
right next to where this defect was?
Yes, with respect to this defect that existed for at least 7 years, 3 flagstones away, you will see in the photographs a guardhouse. It's manned 24 hours a day by the city's lessee. With respect to the Department of Transportation, what good would it possibly do to send a notice of defect to the department that has nothing to do with this building that the city owns and nothing to do with its maintenance? It just would exist to save the city liability. I know I've stated my time. I just want to leave the court with one thought. You have this provision. It would be so easy, if this was what the city council wanted, to put in that subdivision B, notwithstanding any of the provisional law, except for the City of New York, or words to that effect. Would it have been enacted then? And the arguments being made that, well, they didn't expressly say including the City of New York. They also didn't expressly say including the Transit Authority or including any of them, including the State of New York, including any other entity. Thank you for your time.
All right. Thank you both very much for the arguments and have a good day. Thank you.
Thank you.
The next case for argument is Augusto versus 1 Sador Lane. Appellant, please. Ms. Giannaros. You're on mute, Ms. Giannaros.
I'm sorry about that.
Yeah, okay, now you're okay.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Giannaros for the defendants. Your Honors, the defendants here established below that a storm was in progress at the time of the plaintiff's 7 a.m. accident. It's uncontroverted that at that time, the temperature was below freezing and freezing rain was falling, causing a thin layer of ice to coat all of the exposed surfaces. Now, this ongoing precipitation, which was conceded by the plaintiff's own expert, was supported by the Doppler radar images, which were zoomed in over the precise incident location and showed that freezing rain was falling 6 minutes before the accident, as well as the weather records here showing that rain was in fact falling at 7 a.m. that morning. Not only did the defendants establish that there was an ongoing storm at this time, but the defendants also established that the ice involved in the accident was not pre-existing. First and foremost, the records here show that the last time it snowed before the accident was 9 and 12 days respectively before the accident, where a mere total of less than 3 inches fell, which was followed by a period of a 6-hour rainfall a few days thereafter.
Well,
and the records show.
Excuse me. Even if we were to say, okay, yes, the defendant made out the prima facie showing here, isn't there a problem because the plaintiff testified that in fact it was not precipitating right before the accident, and the plaintiff's meteorological expert indicated that that there was not, that there was the precipitation that was falling would not have created any kind of a problem at this particular time. So doesn't that at least raise an issue of fact?
It doesn't, Your Honor, for 2 reasons. First, plaintiff's testimony was that it wasn't snowing at the time of the accident. She never testified that it wasn't raining at the time of the accident, which is the distinct weather event that we're talking about here. Even if she testified to this, her own expert conceded that it was raining at the precise time of the accident and that there was freezing rain happening. And finally, even if it was not raining at that exact moment, the records show that it was raining before the accident at 7 a.m., before the 7 a.m. accident, after the 7 a.m. accident, and thus any lull in activity at 7 a.m. wouldn't even have given defendants the reasonable amount of time to abate this ongoing icy condition. And with regard to the plaintiff's experts' conclusion that yes, there was freezing rain, but it wasn't enough to wet the ground, this is entirely conclusory, and there's nothing in the affidavit that explains why precipitation from the sky would not wet the ground that is freezing, which would cause the thin glazing of ice that plaintiff specifically identified as what she slipped on. In any event, the expert's theory was entirely conclusory and speculative. He stated that, yes, there was ongoing precipitation at this time, but rather the ice that plaintiff slipped on was formed from the small and meager amount of snow that fell 9 and 12 days before the accident, again, followed by a 6-hour rainfall. The Court of Appeals in Bernstein specifically addressed the speculative nature of such an opinion. And in fact, none of the plaintiff's experts' weather records here even confirmed that there was any ice or snow on the ground between January 11th and January 18th, the date of the accident. But this isn't only speculative, it entirely disregards the plaintiff's clear testimony describing the ice. She said that the ice was very clear. It was a sheen of ice that covered the entire walkway, and that it was so clear to her she couldn't even see it. It wasn't visible to her. And yet the plaintiff's expert would have the court believe that this ice instead formed 12 days before the accident, when there was followed by a 6-hour period of rainfall. The Court of Appeals already addressed that this is a speculative opinion to make, and the fact that it contradicts and fails to even address the plaintiff's own description of the ice, which was consistent with our experts' findings here, renders his opinion entirely conclusory. So this isn't a battle of the experts case. This is a case where the plaintiff's expert failed to raise a question of fact by virtue of these speculative and conclusory opinions. For that reason, we request that the complaint be dismissed.
Okay, thank you. You'll have a minute for rebuttal. Can I hear from the respondent, please?
Good afternoon, Your Honors. Can you hear me all right?
Yes.
Jeff Sheetzold for the respondent. Your Honor, I'll get to the points made by counsel in a moment. This comes down to two primary arguments for us. Firstly, it's that the appellant failed to make out a prima facie case because the expert affidavit is insufficient, given that it didn't address the testimony of the defendant's own witness, which contradicts the conclusions that their expert came to. The boots on the ground that day, both the plaintiff and the defense expert both say there's no precipitation before the fall. And counsel incorrectly quotes their own witness's testimony in their papers, and saying that the witness said that only that it wasn't snowing at 6:50, but the witness in fact said it hadn't snowed at all prior to 6:50, and it started snowing while he was in the office at some point after the accident. And that is at page 274 of the record. So what we've got is a defense expert saying, 3 years later, looking at some meteorological data and saying it wasn't snowing, or that it was snowing or raining at the time. But we've got two people who were actually standing there saying it wasn't precipitating at all. And secondly, it is a battle of the experts. When counsel says that the plaintiff's experts' opinions are conclusory, what it really means, I think, is that they don't like the conclusions. These guys both looked at the same set of data, and they came to different opinions. This is a classic battle of the experts. It's a credibility issue that needs to go to a jury. They looked at the same data, and one of them thinks there was snow on the ground. One of them thinks there wasn't snow on the ground. One of them thinks that the precipitation started at one point. Another one thinks it's at another time. One of them says trace precipitation wouldn't have allowed for a freezing condition on the ground. The other one says it would have created ice in 1/10 of an inch in size, whereas the defense own expert said it was a 1/4 inch in size. So that's where we are in terms of the arguments. The defense expert said, and I'll give the record quotes here. At 6:50 a.m., it was, quote, nice and clear, and that's in the record at page 267, and that the rain started while I was in the office after the accident, which is 274. The plaintiff herself said it hadn't precipitated at any point prior to my fall. The plaintiff's expert says this condition likely existed for about 35 hours prior to the accident, and he bases that on the temperature records. And just to address the issue of whether there was snow on the ground, the defense expert says, I looked at the records and there's no snow on the ground, but what he really means is that the weather station several miles away said there was no snow on the ground in areas where it was undisturbed and where it was not exposed, or where it was exposed to the sun. This isn't an issue of undisturbed snow. This is an issue of snow that was shoveled and piled, and furthermore, it's sitting in the shade of a building where it's not being exposed to the sun. So in summary, it's really a question of the boots on the ground are saying no precipitation, and this guy comes in 3 years later and looks at some data and says, oh, it was raining. But I mean, if you look at those Doppler reports, it's just a big blue splotch over Westchester County in the Bronx. Like it's impossible to say it was precipitating in any cognizable area in that one spot.
Oh, okay. I think we got your argument, so thank you. We'll take a look. Ms. Gianaros, do you have any brief?
I just would like to clear up a few things said in response to my argument here. Plaintiff, I want to be clear, never testified that there was no precipitation. She only testified it wasn't snowing. We know that it wasn't snowing. We don't contest that. We say it was raining. Their own experts' records confirm that at 6:56, at 5:26 at the record, there were trace amounts of snow falling. We have that confirmed from the plaintiff's own expert. She testified that on the morning of her accident, there was no snow anywhere. So this idea that there was snow piled up on the walkway is ludicrous on its face. It's not even supported by the plaintiff's own testimony here. There's also no testimony that this snow pile was sitting in the shade. There's literally nothing in the record that a snow pile or even a portion of the building casted shade onto the walkway. That appears for the first time in the plaintiff's expert's report, and there's nothing in the record to support that. So again, the facts here are confirmed by the plaintiff's own evidence was that it was raining at 7 a.m. The ground was freezing for over 36 hours. It created a coating of glaze on the walkway, which is exactly the type of ice that plaintiff testified she slipped on. So all in all, this isn't a battle of the experts case. This is an entirely speculative and conclusory opinion, and the defendants established their prima facie entitlement to judgment as a matter of law.
Thank you. Thank you both.
Thanks.
The next argument is People versus Thomas.
Yes, Your Honor. My name is Shane Baumgardner. I'm appearing for Mr. Thomas.
Can you put the volume up just a little bit, Mr. Baumgardner?
Yes, is that better?
Still low.
Not really, but.
Okay.
Try to talk now.
How's this, Your Honor? Is that better?
Yep. And Mr. Baumgardner.
I'm sorry. Can you hear me now?
Yes. I think
okay.
This is better. So let me before you even start arguing, I read the briefs correctly. I see that the people consent to a remand for an evidentiary hearing on the CPL 330-30 motion about setting aside the verdict based upon the issue with the juror.
That's correct, Your Honor.
So are we going to just skip that issue and go to the other issue, or?
So there's two issues here, Your Honor. We don't think that a remand is necessary for two reasons. First of all, we believe that Mr. Thomas's convictions, both of his convictions, should be vacated because they were based on insufficient evidence and against the weight of the evidence that was presented at trial. Secondarily, we think that the record on the juror misconduct issue is sufficient that this court can rule without remanding for an evidentiary hearing and vacate the verdict and order a new trial. I'd like to begin with the issues of sufficiency and weight.
Okay.
First of all, both of Mr. Thomas's convictions must be vacated because there was no evidence in this case that demonstrated his identity beyond a reasonable doubt. As the trial court said, quote, "This is a case where the only identifying information, only information for the jury, was that of the video," close quote. But this court's precedent and the trial court's own rulings at the suppression hearing in this case show that that video was sufficient to create at most reasonable suspicion as to Mr. Thomas's identity and does not establish his identity beyond a reasonable doubt. Consistent with the trial court's ruling in this case that images from this security video were insufficient to establish identities for purposes of even probable cause, that video could not establish Mr. Thomas's identity beyond a reasonable doubt without some plus factor or other piece of evidence, which is absent from the record here. So as a result, both of Mr. Thomas's convictions should be vacated on that basis. Additionally, Mr. Thomas's conviction for burglary in the second degree must be vacated because the people failed to prove the essential elements of burglary. And I'd like to focus on the knowing and unlawful entry element of the burglary offense. With respect to the unlawful entry element, the surveillance video here provides ample reason to believe that the man pictured in that video had actual permission to enter the complaining witness's apartment.
Isn't that somewhat left up to interpretation because Miss Gaskin, the complainant, indicates that when she put her hand up, it was like to stop. Now you're saying that he hugged her and she seemed to sort of hug him back, kind of. She indicated she was really, really drunk. And apparently there was testimony that she had had an awful lot of drinks right before this incident, and she doesn't even remember some of it. But wasn't that up for the jury to determine based upon the testimony that they heard as to what all those different, hand up meant and the different gestures?
Respectfully, Your Honor, I don't think it was. The complaining witness doesn't just testify that she doesn't remember some of the events. She doesn't remember any of the events that are pictured on that surveillance video. So her testimony about what she did or didn't mean by a particular action when she admits she has no memory of that time period, that's not reliable evidence, Your Honor. And in addition to that, I would agree with you. The video is ambiguous. That's sort of the point here. There's a friendly interaction. There's certainly the one hand raise, although I'll note the people abandoned reliance on that particular gesture on appeal. They don't argue that that gesture meant that that the man pictured in the video, did not have permission to enter the apartment. But there's reasonable doubt here. At bottom, what the people ask the jury to do and what they're asking the court to do is to look at a silent movie and speculate about what a vague hand gesture means or about what a glance in a particular direction might mean. That's not proof beyond a reasonable doubt, Your Honor, and that's particularly true when you view the video as a whole, and it shows really an ongoing friendly interaction. It shows the man making his presence known to the complaining witness throughout the time that she's in the vestibule searching for her keys. He cracks the door and tries to speak to her. That's not the action of somebody who thinks that he doesn't have permission to enter the apartment. It's not the action of somebody who is trying to avoid detection.
Well, what about the fact that the video showed that he kept looking over his shoulder when he was watching her inside the vestibule while she was apparently looking through her purse to find her keys? What was he looking for? What was he checking out for? I mean, how do you interpret that?
Sure. You could ascribe a nefarious motive to, I guess, looking back and forth while you're standing on the street. But two things. First of all, during that same time period, he's also cracking the door and making his presence known to the complaining witness. And he's standing there where she can see him through the vestibule door. He's not hiding. And then the second thing I would say, Your Honor, is he's standing there for 30 seconds while she searches for her keys. As you noted, she was very inebriated. It took her a while to find her keys, and he's standing outside with nothing to do. I think you could certainly say that he was just bored. He's looking up and down the street. And again, it's a silent video. We don't know if there are noises that, there's a garbage truck down the street that makes a big noise. He looks down the street at the garbage truck. So we don't think that those glances show anything. Certainly, they don't show anything beyond a reasonable doubt.
So what about the fact that when she opens her apartment door, he rushes into the vestibule and then disappears, and then comes out and he's seen running with her purse?
Sure. So the people characterize that as him rushing in to catch the door before it slammed in his face. I think that what's really important here is that he's right behind the complaining witness as she's entering her apartment. There's no attempt to sneak in here. He's maybe one step, maybe two steps behind her. Again, we don't think that's evidence that he was knowingly and unlawfully entering the apartment. It's the opposite. That's the action of someone who believes that they have permission to enter that apartment. And that's really all it takes, is his honest belief. As to him exiting the building with the purse, there's a period of 3 minutes actually in between that. Some of the cut-ups don't quite show that, but it's a 3-minute gap. So he enters the apartment building, and then there's a 3-minute gap, and the purse was actually taken off of the complaining witness in her apartment. We know that from her testimony. So it's not as if he takes 2 steps into the building, grabs the purse, and leaves. There's a 3-minute gap, and they actually go up a flight of stairs before that even occurs.
Okay, thank you. You'll have a little bit of time for rebuttal. I'll hear from Mr. Hughes now.
Good afternoon, Your Honors. John Hughes for the people. As Your Honors noted, we have consented to an evidentiary hearing regarding CPL 33030 motion. Of course, if the court has any questions on that topic, I'm happy to answer them. But I'd like to respond to defense counsel's comments about the legal sufficiency and waive the evidence issues. First of all, with respect to identity, a single piece of persuasive evidence can absolutely prove identity. And that can be DNA, that can be a credible eyewitness testimony, or like here, it can be a video that shows the defendant committing the crime. I'm sure Your Honors have seen many surveillance videos in your time. I think the one here is actually of fairly high quality. His face is clearly visible on that video. And of course, the jury got to see the defendant in court and then also compare his appearance right in front of them to the video. And they were plainly like in the best position to determine whether or not it was him. And then with respect to the intent and knowing trespass elements of burglary, again, you know, the video really speaks for itself here. This woman's coming home late at night. She's very drunk. Defendant is following behind her. When he starts to follow her into this vestibule of her building, she turns around. She puts a hand up like this, which we do mention in our brief, and I think it's clearly a stop gesture. At that point, he sort of leans forward and hugs her. Sure, she doesn't fight him off, but you know, it's late at night. She's drunk. She's in this vestibule by herself. And she really has nowhere to even back up. So frankly, I think it was understandable under the circumstances for her to, you know, I guess you could say let it happen, but I don't think she had much of a choice in the matter. Then after that happens, like she turns around and is not facing towards defendant again. Defendant walks all the way out of the vestibule, and he's standing outside and the door is separating them while she's looking for her keys. During that time, they don't appear to interact on the video. They don't appear to be talking. Their mouths certainly aren't moving. As the court noted, you can see defendant quickly, you know, checking behind him, I think multiple times as well. When she does finally unlock the door and walk in, you know, she just goes in by herself. She doesn't hold the door for him. She doesn't wait for him. She doesn't turn around to be like, hey, the door's open. She just goes in. And then you can really see defendant opening the door and darting in himself. And then, of course, it's only a few minutes before he goes running back out with her purse. So, of course, the jury here is entitled to look at this and draw any reasonable inferences from the video. And this is really, you know, really the jury's providence here. If Your Honors don't have any other questions, we'll rest on the arguments in our brief and ask that you affirm. Thank you very much.
Thank you. Mr. Baumgartner?
Yes, thank you, Your Honor. Just briefly on the video, you know, we do believe that it shows a friendly and ongoing interaction, and ultimately, we think that there's ambiguity here, and that's what it comes down to. And we think that it was, you can certainly speculate as to the meaning of certain gestures. You can speculate to the meaning of certain things, but that's not proof beyond a reasonable doubt. So that's our point on the video and on the burglary elements. I'd be remiss if I didn't just briefly address the jury claim. We believe that the facts here are undisputed, that the juror number 2 made a statement that she remained on this jury because the complaining witness would need her. We think that that record is clear now, and there's no need for a remand for an evidentiary hearing in order to vacate this verdict and order a new trial based on both juror misconduct and based on bias in this case.
Okay, any more questions? Well, Mr. Baumgartner, I believe that you were doing this on a pro bono basis from the firm of Gibson Dunn. Is that correct?
That's correct, Your Honor.
Okay, so we want to thank you very much for your argument, and please thank your firm for letting you do this pro bono work, and good arguments from both of you. Thank you very much.
Thank you very much, Your Honor.
Thank you, Your Honor.
This afternoon. Thank you. The next case for argument is Scottsdale Insurance versus RLI. Okay, Mr. Delahunt, you are the appellant, I believe. Okay, you're still on mute.
Thank you, Your Honor.
That's
yes.
going to be the word of the century. You're still on mute, or at least of the year. Okay.
May it please the court, Timothy Delahunt for defendant appellant RLI Insurance Company. The issue in this case is an important one, but the analysis is a straightforward one, and that is, did the court below apply the policy as written? As written, the policy allows an offer of limits to terminate the coverage obligation for interest. An offer is sufficient without on its own to terminate the coverage obligation.
But isn't the problem in this case that the offer was allegedly made on the record in the courtroom, but the transcript from that day doesn't show that offer being made? It's not, somehow it didn't get onto the transcript, or it wasn't made. I don't know what happened, but it's not on the transcript. And the attorney that allegedly made this offer in the courtroom sent an email to his claims rep saying, by the way, I did what you told me, I made the offer, except Mr. Bacalor, who I knew many years ago, passed away before he had a chance, before this motion was made. So how do we know? I mean, I know how it was written. It's just that how do you prove it given this unusual set of circumstances?
Right. I think there are two aspects to the appeal, the legal issue, which I started with, and then this is the evidentiary issue. And what I would say to that is, I believe Justice Crane raised the exception for a statement against pecuniary interest, sua sponte, but I believe that the judge was correct. The email evidence satisfies all the elements of the exception, and I'm happy to go through them. But you know, the larger point I referred to in my briefs is the excess carriers took, they made an admissibility argument, but they didn't proffer any real evidence to rebut whether Mr. Bacalor made that offer. And so the evidence, the admissible evidence in the case is entirely RLI's, and there is no other evidence on the other side of the scale. So if the court were to determine that quantum of evidence is sufficient, that would resolve the evidentiary issue. And the larger point I made in my brief, and I made below in the arguments, is that it's certainly possible. I think that, like I said, I think Justice Crane got this right, and the evidentiary issue is resolved. But if this court were to remand for an evidentiary hearing on that issue, what it would entail is something along the lines of having the claims examiners and the lawyers and everyone who was in the courtroom that day to come in and testify in theory. And if there was any real question that Dick Bacalor made this offer, this is a closed setting, then I would hope that the parties would come forward prior to this date or prior to the appeal and to say, Dick Bacalor never made that offer. RLI never put its limits on the table. This is a serious evidentiary issue. And I think that the evidentiary issue, you know, the excess carriers made the arguments that they're entitled to make. It's their prerogative. I view the evidentiary issue as not only being correctly resolved, but at most the tail of the dog here.
Counsel, this is Judge Mendez. When I read the transcript, what I aside from not seeing anything there from Mr. Bacalor saying that he was making an offer on behalf of RLI, what was in the transcript was a statement from a co-defendant saying, since they're not making an offer, my offer, which I made, and I wanted for everybody to put up $1 million, my offer now is off the table. So isn't that evidence alone that Mr. Backlor did not make the offer that RLI was going to be putting up its policy.
Right. You know, and I addressed this in the reply brief. When Your Honor, when you refer to the attorney on the record saying they haven't offered their limits, the they was Navigators and RLI, and that observation was made in the morning. Dick Backlor made his offer that afternoon, and for RLI, and put its offer on the table. So it's perfectly consistent for the attorney in the morning for I believe it was State National to say my million was on the table, but these other two carriers haven't done likewise. I'm taking mine off. And then in the afternoon, RLI to say no, our million is on the table, but Navigators was and remained the holdout there. So the morning email and Dick Backlor's offer is consistent. And again, to reiterate my prior point, if there was a substantial question that that's not how in fact it unfolded, then practically, if not legally, it was incumbent on AIG, Scottsdale, and the others to say that's not what happened, rather than just simply fight it on, the rules on exceptions to hearsay.
Okay. Can we hear? You'll have a minute or so for rebuttal. Can I hear from Ms. Odelson, please? And you're on. Oh, now you're. Wait.
Sorry, I am stuck in the 90s with the technology. My name is Ann Odelson, and I represent Scottsdale. With respect to this matter, we're an excess insurer. I think the justices, you picked up on it. There's no evidence that this offer was made. I don't think the judge ruled that this was an exception to the hearsay rule. In fact, it's not. If you look at the circumstances, in the afternoon where this offer to settle the case, and it wasn't an offer to pay, it's an offer to settle, which is completely different. That's not on the record, but what happened was when they came back, or in the afternoon, defense counsel started examining a witness. Mm-hmm. So the circumstances surrounding when this alleged offer to put their policy limits on the table was made, it is lacking. So I don't even think we can go, to whether it wasn't made. It's questionable whether it was made. But I think this court, in a related case, talks about there's got to be an unconditional offer to pay the limit, no strings attached. The offer to settle a case is not the same as an offer to pay. And while New York courts have kind of addressed this issue, other courts have really addressed this issue. It has to be unconditional. And I think the trial court's ruling shouldn't be disturbed because this one email that said, oh yeah, we made an offer to settle, isn't the same as basically what this court found in this related action involving State National. State National, in the underlying action, wrote a letter, made an unconditional offer to pay its policy limit, calculated some interest in that, and this court found that was significant to extinguish its interest obligation. There has to be something more than just a tendering of the limits. And by ruling that anybody at any time can just say, yeah, I'm going to put my policy limit on the table and cut off his interest obligation, it's really going to wreak havoc in New York courts because it has to be unconditional. So that's an offer, like I said, an offer to settle a case is not the same as an offer to pay. And I think the court's ruling should not be disturbed in the underlying action.
Thank you, Ms. Odelson. And the co-respondent?
Yes, Elizabeth Allstrand, may it please the court. I'm here for the insurance company of the state of Pennsylvania. And I would echo what Attorney Odelson just said. Our position is certainly aligned with Scottsdale's. But just to touch quickly on the hearsay issue, we didn't have a burden before the motions court to produce evidence, admissible evidence that this offer did not occur. It's the moving party's obligation to come forth with admissible evidence of all the material elements of their case. And here, the critical element in the first instance is, did an offer occur? And they did not produce admissible evidence of that. I dispute that Judge Crane even found that the hearsay exception for interest against pecuniary interest could apply. She mentioned it as an aside. But it really doesn't apply in this case. RLI making a settlement offer is not against its pecuniary interest. It's not an admission of liability. It's not an admission of coverage. It is, an attempt to resolve a disputed claim. It's a settlement offer, if it happens at all. And also, the indicia of reliability are just certainly not there when you have a transcript from the day that completely conflicts with your hearsay statement. Now, just to touch quickly up on the issue of whether the offer itself would have met the policy provisions. I mean, it's pretty clear that the courts that have looked at this in New York and also outside of New York, while not binding on this court, are certainly informative. All of those decisions have found that the offer has to be unconditional. The RLI's counsel has not identified a single case in New York or outside of New York where an conditional offer, an offer that required the release of the plaintiff's claims or had other conditions attached to it, was sufficient to meet the policy's provision and escape clause with respect to the interest. So, like Attorney Olson, I believe that the trial court got it right and that the decision should be affirmed.
Thank you. Mr. Delahunt, do you have any brief rebuttal?
Yes, Your Honor. I only have 2 minutes. The issue of the sufficiency of the offer, evidentiary issues aside, the legal issue is a very important issue. I briefed it extensively. I wasn't able to argue it extensively here today, which is the way it happens. It's in the briefs. But I would say this is an issue of first impression. So when AIG and Scottsdale say RLI hasn't come forward with a case in support of its position, well, the AIG and Scottsdale have only come to the court with auto regulation cases. They have not come to the court with a case that supports their proposition. That's why it's an issue of first impression. AIG handpicked some cases from outside New York, but most, if not all of them, as I point out in my reply, support RLI's position. If I would put a succinct analogy here or argument here, if you look at the RLI versus Navigators case that this court decided as a part of this underlying Simon case, the gist of the two cases is the same. And if there's not a reversal here, they will be irreconcilable. Because in RLI versus Navigators, this court held that a judgment is not required for the carrier in that case to have satisfied its obligation, to have cut off its interest obligation by tendering its limits. And that's because the policy didn't require it. The specific interest issue here is somewhat different, but the fundamental principle is the same, which is if the court does not allow RLI's offer to pay to be sufficient, if there are other conditions, unspecified, other requirements, then that would be the same thing that this court rejected in RLI versus Navigators, which is to say the court will apply a CGL policy as written. Thank you.
Okay, thank you all very much. Appreciate the arguments. Have a good afternoon. The next case is Paulino versus MTA Bus. Appellant?
Yes. Good afternoon, Your Honors. May it please the court. My name is William Morrissey, and on behalf of the defendant appellants, I want to show the court that the lower court should have granted summary judgment on these facts. There are two essential facts in this case that proved defendants were entitled to summary judgment, both of which can be gleaned from the testimony of the plaintiff himself. One, that the plaintiff was opening his door on the side of moving traffic in violation of VTL 1214, and two, that the impact with the door between the door and the bus happened to the right side of the bus. Now, there are slight variances between the testimony of the plaintiff and the testimony of the bus operator about where that impact was on the right side of the bus. The plaintiff said it was in between the front door and the middle door, which there's only two doors, so I assume he meant the rear door. The bus operator said that it was just behind the rear door, but both of them said it was somewhere in that midpoint of the side of the bus. And there's photographic evidence in the record on page 476 of the record. This is the photograph that appears on the record, and it shows the impact as confirmed by the bus operator on page 428 of the record, right behind the door, just below the rear window of the bus. This case is consistent with Gonzalez versus O. Timbellis, decided by this court in January of this year. It's the same case as Smith versus City of New York, also decided by this court this year. And it's the same case as the Tavares versus Harassme case, decided by this court. The facts are the same. Now let's talk about some of the things that plaintiff has attempted to put forth to suggest that this case is different. For one thing, plaintiff offers the testimony of the plaintiff that he began to open the door while another car was passing him before the bus did. And that testimony, by the way, appears on page 210 of the record. On 215 of the record, the plaintiff said that the time span between when he started to open his door and the impact was 2 or 3 seconds. That was the plaintiff's testimony. So based upon that, plaintiff urges that that was sufficient evidence to deny the motion for summary judgment. It wasn't. Why not? 2 reasons. Number one, it doesn't change the fact that the impact still occurred to the side of the bus, showing that the door swung into the bus. Number two, 2 to 3 seconds isn't a heck of a lot of time to react and respond in a traffic situation. So in neither case is that testimony by the plaintiff sufficient to distinguish this case from the cited cases, all decided by this court. This idea offered by plaintiff that a protrusion on the side of the bus may have been the culprit in the accident and may have caused the accident. It's first of all, it's wholly inconsistent with the testimony in the case. Nobody said, neither party said that a protrusion caused the accident. The plaintiff said, I looked and it was, and his testimony appears on page 111 of the record. It was on the side of the bus, in the middle of the bus, between the 2 doors. The bus operator pointed out specifically where on the bus it was and the damage, which again is shown on page 476 in the record. And there's a little dent right below the mirror behind the rear door of the bus. It wasn't a protrusion. Plaintiff's counsel looked at the photograph and said, well, there are protrusions. There's a little yellow light on the bus. And he offered that as a pot.
Let me just ask you a quick question. Wasn't there evidence that the plaintiff opened the door while traffic was stopped and that there was sufficient room for a prior car to pass him without hitting the car? So whether or not his opening the car on the side into traffic was actually the proximate cause of the accident is an issue of fact.
Yeah, it's not an issue of fact in this case, because once again, the point of impact, whether the bus was stopped, the bus driver said the bus was stopped before he moved forward. The plaintiff said the bus was not stopped. It passed him without stopping. But the point of the matter is the impact is still to the side of the bus. It's not in front. It's not like the bus operator had an opportunity to avoid it. And it's not like the forward motion of the bus caused this impact, because it didn't hit the door. It didn't hit the door. The door hit the side of the bus. And that's the only possible interpretation of the physical evidence of this case.
Okay. So that. Okay, why don't you just finish up, because you've used your 5 minutes and you will have 2 minutes for rebuttal, okay?
Yes, Justice Kaepernick. Just summing it all up then, this case is just, right on point with the cases decided by this case, by this court before. The damage is to the side of the bus, and that in and of itself establishes that there was nothing the driver could have done to avoid the accident. Thank you.
Thank you. May I hear from the respondent, please?
Good afternoon, Your Honors, as well as Mr. Morrissey. May it please the court. I think at the outset, the mistake that defense counsel is making in characterizing the evidence is by saying that the only possible explanation for the points of contact between the plaintiff's vehicle's door and the side of the bus is that plaintiff opened the door into the side of the bus. The problem is that's not accurate. The alternative explanation is that the bus is traveling at a bit of an angle. Now, The evidence indicates that the bus actually had every reason to be traveling at an angle, specifically because the bus driver testified that he was basically moving back and forth in order to avoid parked as well as double parked vehicles along the street. That had been going on for some distance prior to him ever reaching the plaintiff's vehicle. If he's moving around the plaintiff's vehicle, which again is a little bit of a distance away from the curb by all accounts, then that inherently means that the front of the bus is moving to the left. That also means that it's traveling at an angle and it exposes the rear portion of the bus. And that's exactly how you arrive at those points of contact without the plaintiff having opened the door. Now, Justice Kapnick, as you pointed out, the testimony here is that another vehicle, an uninvolved vehicle, passed by the plaintiff's vehicle about 2 to 3 seconds at least before the bus ever arrives next to the plaintiff's vehicle. The important thing to note there is that he testified, and this is undisputed testimony, that his door is already open at that point. Not that he was opening it, but that it was already open, and he was in the process of getting into his car when that happens. So that differentiates this case from a lot of the cases cited by defendant's counsel, Gonzalez, Smith, Tavares, because the common thread running through those cases is that the vehicle involved that opens the door in those cases was opening it either into oncoming traffic directly as that traffic was alongside or parallel with the vehicle that opened the door, or at such a point where there was absolutely no opportunity for the vehicle that ultimately struck the door to avoid doing so. But in this case, there is obviously the difference of time as to when the bus arrived next to the plaintiff's vehicle. There's also the difference of distance, because the testimony here establishes that even though the plaintiff's vehicle was parked a little bit of a distance away from the curb, he also testified that there was 1 meter to 1.5 meters between his door and the vehicle that passed by ahead of the bus, and that gives you about roughly 3 to 4.5 feet. That indicates that vehicles were able to pass by the plaintiff's vehicle without any incident, without difficulty, and that in turn raises the question, especially in light of the very low speed of the bus, as to whether or not the bus driver was also negligent. Now, another issue in this case and in this appeal is whether the video, frankly, should be considered or not. I don't want to spend a ton of time on this because I think the argument is set forth pretty straightforward in the brief, but at the end of the day, if the video is not considered, which plaintiff's position is that it should not be because of the various authentication issues, then you've got almost diametrically opposed instances of testimony or accounts of how the accident occurred between the plaintiff and the defendant. And therefore, it's not quite as simple as saying the only two things that matter here are whether the plaintiff opened the door into the side of the bus, because it also matters whether the bus was stopped or moving at the time, and whether the door was already open versus whether it was opening as the bus passed by. And that's what you're left with when you don't consider the video and you do consider the testimony of the bus driver and the plaintiff. So bottom line is there are sort of questions of fact abounding, if you're left with just the testimony of the parties.
Okay, thank you very much. Mr. Morrissey, any rebuttal?
Yes, very briefly, Your Honor. First of all, it doesn't matter whether the bus is stopped or whether it's moving. The impact is still to the side of the bus, almost near the rear of the bus. Secondly, counsel said that the door was already opened. He wasn't opening it. This is a misinterpretation of the testimony. The testimony in question appears on page 209 and 210 of this record. The question was, at what point did you start opening the door? Was it before the car passed or as the car passed you or something else? Answer, it was a combination. While the car was passing, I was opening the door. He then testified that it was only 2 or possibly 3 seconds before the impact. So even if counsel's correct that somehow the bus through an angle or lateral movement could have initiated this contact, it was only 2 to 3 seconds before he started opening the door and the impact. So there's very little that the bus driver could have done to avoid it. And no, it's physically improbable that a slight angle could have caused the bus to hit the car door with this part of the bus. if the impact was to the rear corner, if it was to the rear corner of the car or something like that, then possibly you could say some angle would have caused it. But the impact is right below the rear window of the bus. There's no angle. If you try to figure it out in your head, that could somehow concact that part of the bus being thrust into the plaintiff's door. But even assuming that it was 2 to 3 seconds between when he starts to open the door and the impact, not enough time for the bus driver to react.
Thank you. Thank you both very much for the argument.
Thank you, and have a nice day. Happy New Year.
Happy New Year to you too.
Thank you, Your Honors.
Thank you. Sands Brothers, Mr. McCarthy, you have 5 minutes. You're the appellant. You're the only one that asked for some time, so we'll listen to you for a few minutes.
Thank you, Your Honor. May it please the court, I am John McCarthy. I represent GEE Group, a public company that's more than a century old, as the plaintiff noted. In 2014, the plaintiff filed summons in this case based on a press release from former U.S. Attorney Preet Bharara. In 2015, they attached that press release to the complaint. 3+ years passed where they took discovery, obtained thousands of pages of documents, took depositions in New York, Florida, Kentucky. There was even a deposition taken in jail and down in Kentucky. Today, we're here on a summary judgment motion, and plaintiff still relies on a press release from Mr. Bharara. This is time for evidence in admissible form, not speculation. This case is primarily about plaintiff's fraudulent conveyance claim. Plaintiffs lent money to an entity called O2HR LLC. It's undisputed that O2HR did not transfer assets to GEE or its subsidiary Triad in any of the transactions at issue here. The 2010 transactions or the return of GEE's $2.3 million. Even plaintiff's expert agrees that there's no connection from O2HR to GEE, Thomas Bean, or anyone that purchased GEE stock. So we made a prima facie showing of entitlement to judgment as a matter of law. The burden shifted to the plaintiff to produce evidentiary proof in admissible form. And instead they come to this court with fanciful terms such as vortex of fraud, daisy chains, and consigliere, but no admissible evidence. They have not identified any admissible evidence. They are actually creditors of any of the transferees at issue here. Ask yourself, having reviewed plaintiff's brief and the evidence, do you even know what specific transfers the jury will be asked to analyze if this court denies summary judgment? Plaintiffs have not articulated which series should be set aside, let alone present any evidence that each transfer in the series constitutes fraud or fraudulent conveyance. They tell you a really, really long story with no record support, and that's directly contradicted by the evidence that has, and most of which has nothing to do with this case, or at least with this appeal. In addition, Your Honors, they agree with us that the aiding and abetting fraudulent conveyance claims rise and fall based on how the court determines the fraudulent conveyance claims. So we submit it should also be dismissed for the same reasons. Finally, the last two claims, aiding and abetting breach of fiduciary duty and conspiracy conspiracy with respect to breach of fiduciary duty, as we pointed out, under Credit Agricole, they must exhaust their claim against the entities, in other words, Thomas Bean and O2HR. They claim futility without any evidence, and moreover, Mr. Bean and O2HR are both defendants in this very lawsuit. So unless Your Honors have any questions, we'll rest on this argument and our briefs.
Okay, anyone have any questions? Okay, thank you very much for coming in, Mr. McCarthy. We will take a look.
Your Honors.
Have a nice afternoon. Okay, and last but not least, Week versus LSG Sky Chefs. You each have 5 minutes. Ms. Elsasar?
Yes, thank you, Your Honor. May it please the court, Deborah Elsasser for the appellants. Addressing the relation back argument first, the court's holding that Sky Chefs Inc. was united in interest with the originally named defendants was based on an erroneous factual and legal finding that Sky Chefs Inc. has a vicarious relationship with the originally named defendants. Although the court correctly stated that the United in Interest standard requires a showing that the entities are vicariously liable for each other, the court's finding that the original defendants in this case would be vicariously liable for Sky Chefs Inc.'s conduct is not supported by the record and is contrary to the affidavits that the defendants submitted in opposition to the motion to amend the complaint. And those affidavits can be found in the record at 330 to 339. The affidavits establish that the appellants are distinct corporate entities with different operations. They are not subsidiaries or parents to the entity that plaintiffs sought to add to the case, and they are not legally responsible for the conduct of that entity. The court did not explain how Sky Chefs Inc. How the original defendants would be vicariously liable for Sky Chefs Inc.'s conduct. It appears the court relied upon some type of alter ego theory to find that the defendants all hold themselves out to be Sky Chefs Inc., but there's no evidence in the record supporting that conclusion. To support application of an alter ego theory, as the court is aware, New York law requires a finding that the entities are being used as a mere shell to perpetrate a fraud, or that one entity has complete dominion and control over the activities and operations of the other entity. The evidence did not establish that in this case, and it didn't support application of any type of alter ego theory. Plaintiff argued that the entities, the original defendants and the defendant, the entity he sought to add, had a common parent and common board members. But New York law makes clear that that is not sufficient to either establish alter ego or vicarious liability. And obviously part of the rationale behind the requirement for vicarious liability is to prevent a situation where the originally named defendants do not have the same defenses that the newly added defendant would have, such that the originally named defendants would not pursue evidence and theories of defense during the course of the case that the newly added defendant would be forced to pursue once added to the case after the expiration of the statute of limitations. So here, the originally named defendants had no involvement in any of the operations that form the basis of the complaint in the case. Their defenses are based on lack of personal jurisdiction, which is the second issue I'll address, and the fact that they had no involvement in the operation, so they cannot be held liable for any of the acts set forth in the complaint. That's different than adding a defendant now, Sky Chefs Inc., which did have operations at the airport, which now has to develop evidence that the other defendants had not developed because they were named and Sky Chefs Inc. was not. So there is no basis for the finding of the court that the originally named defendants had the same defenses available to them and would be vicariously liable for the acts of the newly added defendant. The court simply assumed that the defendants were one and the same, contrary to the affidavits that were submitted by the defendants and the evidence in the record. If the court doesn't have any questions, I can turn to the personal jurisdiction and the remaining argument very quickly.
Well, yeah, you have like one.
Oh, okay. Well, the personal jurisdiction finding was factually erroneous as to the LSG Sky Chef Supply Chain Solutions entity. The court's ruling was as to that entity that they were registered to do business in New York and therefore had consented to jurisdiction. They were not registered. As to the other entity, the North American Solutions entity, they are registered as a foreign corporation. But the case law I believe the court relied on was pre-U.S. Supreme Court case law, the recent case law that makes it much more restrictive to assert general jurisdiction over a foreign corporation. Clearly, there was no evidence that they're at home in this jurisdiction. And I think that this court has, in fact, addressed directly that issue, that the registration in New York alone is not sufficient to confer general jurisdiction. And obviously, because these defendants were not involved in any of the operations forming the basis of the complaint, they also would not be subject to specific jurisdiction. And then as to Constance Food Group, which is the last point in our brief, there's just simply no evidence in the record to show that they had any involvement in the operations. So we did not, our argument is that there was insufficient showing to raise an issue of fact to defeat summary judgment based on their non-involvement in this, in any airport operations. And that was based on this affidavit submitted at the record at 339.
Okay, thank you. Ms. Gross?
Good afternoon, Your Honors. May it please the court, Evelyn Gross for the respondent, Walter Week. First, just getting into the united in interest argument, which I believe is the only argument that appellant raises with regard to the relation back doctrine. I believe there is sufficient evidence in the record provided by the plaintiff to show that the three entities are actually united in interest here. For instance, this court has held before that if there is a parent and subsidiary have often blurred the lines regarding the identity of the corporations, then they will be held united in interest for purposes of the relation back doctrine. All the evidence that plaintiff provided herein, which a majority of came off the jointly owned website for all three entities, suggests that they are united in interest and they constantly blur the lines between them. There's constant references to Sky Chefs Inc. And also alternating references to Supply Chain Solutions and North American Solutions. They all talk about their acquisitions of certain companies as one and the same. They constantly alternate their corporate references. In addition, which the appellant never addresses actually in her reply or her brief, on their website, it indicates that all three corporate entities share profits and losses, operating expenses, liabilities. It's specifically in there several times. And with that said, the whole point in united in interest is whether a judgment against one would affect the judgment against the other entities. And in this case, based on that proof, which is the consolidated financial statements and the references to consolidated revenues, consolidated financial statements, consolidated profits and losses, clearly a judgment against one of them would affect the judgment against the others. In addition,
What about the personal jurisdiction issue?
Okay.
I mean, isn't the Court of Appeal, the Supreme Court have said that, you know, the law, I mean, it changed the law, and if you're not at home in these jurisdictions, you can't really get your general jurisdiction here.
Well, I disagree with that. First of all, I believe that there's general jurisdiction and specific jurisdiction against NAS and SCS. First of all, general jurisdiction, plaintiff relies on Daimler. My reading of Daimler, my understanding of Daimler, and several courts have held that Daimler does nothing to change the law with regard to consent. All it simply does is Daimler deals with contact-based issues. And in Daimler, it said that continuous and systematic contacts alone would not, with not regard to the actual tort at hand or the claim at hand, would not be sufficient. In fact, Daimler doesn't even really go into consent. Here, we have NAS, who not only consented to jurisdiction by filing business with the Secretary of State here, but they also have a business in New York. I mean, the appellant admits that they own, I mean, not that they own, that they manage a lounge in one of New York's major airports. In fact, it's the biggest airport. So they therefore have the systematic and continuous contacts here that are so prevalent that I believe they have general jurisdiction between the consent and that. In addition, obviously, there's the alter ego argument where I believe that both NAS, it's clear that NAS and SCS are alter egos of Sky Chefs Inc., which is a New York corporation. It is admitted that it's a New York corporation. With regard to the one corporation which has not consented and is not a New York registered corporation to do business, I've attached several documents from their jointly owned website, which indicate that Supply Chef Solutions actually owns property and owns a New York corporation. They purchased Constance, 100% of Constance / Norris Group within.
Right. I think we got the arguments, and I don't think anybody here has any more questions on that. So we will take a look at the points that you've made. We thank you very much for your arguments, and we wish you, instead of a good afternoon, a good evening.
Thank you.
Looks like it's gotten dark since I said.
Thank you for granting us the argument.
Have a good night. The
Thank you.
Appellate Division First Department is now in recess. The court is adjourned, and this concludes the arguments for today. Thank you very much.
Stay well, everyone. Thank you.